All right. Good morning, everyone. Starting a little late. Apologize for that. I have a list that Ms. Nelson prepared that says, well, I guess with Mr. Can we get Ms. Oh, I have a deputy here. Well, I'm going to talk with you all. We're not talking substantive. With Mr. Hatcher, all we're doing is setting aside a bench warrant or talking about. Hey, can you get Miss? There she is. Good morning. I just wanted to talk about the order of business for this morning. With Mr. Hatcher, we're talking about setting aside a bench warrant.
I think it's bond reduction. I don't think from what I looked at the system, I think about bond reduction.
He did actually.
It's bond related. Okay, I'm going off a script here. I haven't looked at I'll pull up the docket in a minute. But it's bond related for Mr. Hatcher. It's not disposition related, but get out related.
Yes.
Okay. Raymond Washington may be a plea.
Yeah, I think he should be here. So
Is he?
that should resolve today. Let's have to go over the waiver of rights form.
Great.
One is negotiated, one not negotiated.
One of his cases is negotiated, one is not. Okay. Mr. Gill is a plea, I'm told, and he is on the call.
Yes.
All right. And then Edmond should be on, he's not online, maybe he's iPad, I don't know, but.
No, just
He's locked up.
I'm just talking to him as you know, going over the.
He's not a walk-in, all right? That's what my notes here say. And then Lewis and Kemp are, well, Lewis is just a revocation, and then Kemp is revoke the old case, one guy died, so a null pros, and then a plea. Those are Judge Leffridge's cases. You've talked to Mr. Sclafani.
He knows everything.
Great, okay, he knows everything. Then Ms. Willingham had asked that we do Mr. Gill first. Are you okay with that? Will you fit that in, or do you want Ms. Nelson to let Judge Barwick's folks know? You know, it might take more than 11 minutes.
Email them and told them that I would be a little late because I'm not sure, I'm pointing back, I'm not sure if that's Mr. Washington behind me, but.
That is Mr. Washington.
I have his negotiated plea as well.
Oh, so Ms. Nix has half of the situation.
Yes.
Got it. Okay.
But I can email Judge Barwick and let them know just to hold for my absence.
Great. Well, why don't we start with Mr. Gill then? There's Mr. Whoop.
Good morning, everyone.
Good morning, Mr. Gill. Let me just get everyone in their positions. So Ms. Rios, you can either move the screen or move yourself, however you want to do it, so Mr. Gill can see you. Good morning, Ms. Rivers.
Good morning, Judge. How are you?
I'm well. You ready to go?
Yes, I am.
Fantastic. Then I know we're working off a bunch of different calendars, so I'll always say the style of the case for your transcript purposes. What we're going to do now is 25 SC 003046. It's State versus Gill. Mr. Gill is on our Zoom feed. Mr. Gill, before we can start with your plea, are you okay proceeding from wherever you are rather than being here in court? You've got a right to be in court, but you can waive that and tell me, Judge, I'm good where I am. So it's not a trick question. We can wait and you can get a car or a bus or a bike and come down here. And we can do this later this morning, or you can have this conversation from right where you are. What do you want to do?
Right where I'm at.
Okay, good. The other thing I need you to tell me you're okay with is the fact that Ms. Rios, so you can see on the screen there, she's wearing kind of the peach colored blazer. She's your lawyer. And if we were here in court, she'd be right next to you. So you could lean over and ask her a question. But here she's in court and you are in your mystery location, which is fine as long as you tell me you're okay going forward without your lawyer right by your side. Are you okay with that?
Yes, Your Honor.
Okay. If at any point you've got a question, let me know. I'll try to answer it. If it's something that you and Ms. Rios need to talk about confidentially, she can pop outside and give you a call, okay?
Yes, Your Honor.
All right. Ms. Willingham, who is in the red blazer, is going to swear you in, and she's the prosecutor, and she's going to ask you a bunch of questions. Ms. Willingham?
Yes. Good morning.
Good morning.
Raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Please state your true, correct, and legal name.
Jefferson Raymond Gill Jr. And what else?
Can you spell your first name?
Drafus.
Okay. And last name Gill, Gill? Okay.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
I didn't hear your answer.
No.
Okay.
How old are you and how far have you gone in school?
I'm 18 and I was in the 12th grade. I say I had like 3 months left to school.
Where were you going to high school?
Washington High School.
But you didn't graduate.
No, Your Honor.
Okay.
Are you able?
I was supposed to be going back.
Okay. Well, we'll talk about that a little bit later.
Are you able to read, write, and understand the English language?
Kind of.
Okay. If we say anything that you don't understand, will you let me know?
Yes, Your Honor.
Do you understand that you are charged with aggravated assault, which the state will be removing the aggravator in that, Your Honor? It's currently charged as aggravated assault family violence. That charge will now just be a regular aggravated assault, which has a minimum of 1 year and a maximum of 20. And I'm sorry, going back to the indictment. And terroristic threats and acts, which has a minimum of 1 year and a maximum of 5. Possession of firearm during the commission of a felony, which has a mandatory 5-year consecutive sentence. And simple battery family violence, which has a minimum of 1 day and a maximum of 12 months. The overall recommendation in this, I'm sorry, do you understand that those are the offenses you are charged with?
Yes, sir.
The overall agreed upon sentence recommendation in this case is 3 years to serve 6 months. And he would be given credit for those 6 months. As to count 1, 3 years served 6 months. As to count 2, 3 years served 6 months, concurrent to count 1. As to count 3, and I'm sorry, 5 years probation consecutive. So that would be an overall sentence, Your Honor, of 8 years served 6 months. My apologies.
That's okay.
And count 4, serve 6 months. You are required to have no contact with the victim, complete anger management, stay away from the incident location, and complete 60 hours of community service. Is this what was explained to you by your attorney?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead guilty or remain silent, you may receive a jury trial.
I understand.
And have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney? I'm sorry, you have to answer verbally for the court reporter.
No.
And are you satisfied with her services? Ms. Rivers, were you able to hear his answer?
Hey, Mr. Gill, just make sure, pretend like we're outside and you're having to yell over a crowd. Were you happy with the work that Ms. Rios did for you?
I think his sound went off.
I think so too.
Your sound went away.
She's doing a great job.
All right, now we can hear. You said she did a great job. Okay, all right, make sure you speak up. She really wanted to hear you say that she did a great job. She wanted that to be loud.
I'm sorry. Have you reviewed this indictment with your client, Ms. Rios? Yes. And do you waive formal reading of the indictment? Yes. Are you satisfied your client has a full understanding of this proceeding? Yes. Has your client been arrested on these charges? Yes. And the state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges? Has your attorney advised you of those minimum and maximums that we went over earlier, Mr. Gill?
Yes.
I can hear him, but barely.
Yes.
Okay.
Okay.
As long as you can hear him,
As long
but
as
keep
you-
it up, Mr. Gill. You're not going to offend us if you yell.
Yes.
Great, that was better.
Better.
Are you aware that the court does not have to accept the recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes. Yes.
Do you understand that you do not have to accept the court sentence and you may withdraw your plea on this case as it appears on a calendar at a later date?
I would take it.
Say that again?
I said I would take the plea.
Okay, but just so you're clear, if today I disagree with this recommendation, and let's say I say you got to do 15 years probation rather than 7.5, which is what was negotiated, you would be able to say, no, thank you, Judge. I agreed to what this offer was, not this other thing that you did. So today you could say, no, thanks, and back out of it. After today, no, you're stuck with whatever your plea is. But today, if I differ, if I do something different, you'll be able to talk with Ms. Rios about whether you still want to go forward, okay?
Yes. Yes, Your Honor.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
I understand.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
I understand.
Do you understand that by pleading guilty to a felony, if you receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
I understand.
Do you understand that you are not allowed to possess or use a firearm while on probation, even if sentenced pursuant to the First Offender Act?
I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I understand.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of aggravated assault, terroristic threats and acts, possession of a firearm during the commission of a felony, and simple battery, family violence in indictment ending in can you help me out? I'm sorry.
The indictment ending in 046.
Thank you. How do you plead to these charges, Mr. Gill?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
I got one question. Like, what is a conviction?
So conviction means when we're all done, if I accept your guilty plea and sentence you, when we finish, then you will have a conviction. This case will mean that you were convicted of aggravated assault, terroristic threats. And so could have consequences in the future. If you get in trouble in the future, a judge might say, well, dang, Mr. Gill, you did this before. Last time you just got probation. This time it may be more serious consequences for you.
And Mr.
Hold on one second. Did you have a question?
No, Your Honor. I just wanted to know that. Thank you so much.
Okay.
I'm going to do it.
Okay.
And Mr. Gill, it is my understanding you are asking to be treated as a first offender under the provisions of the First Offender Act. Is this correct?
Yes, sir. Yes.
And have you ever pled guilty or nolo to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
I understand.
Do you still wish to be treated as a first offender?
Yes. Yes.
Okay. And do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I understand.
Just one moment, Your Honor. I'm going to switch over to the factual basis. Your Honor, if this case were to proceed to trial, the state would expect to show that on April 10, 2025, officers responded to 3223 Greenbrier Parkway, Atlanta, Georgia, in Fulton County regarding a domestic dispute. Upon arrival, officers spoke with Ms. Southall and stated she was assaulted by her live-in boyfriend, Mr. Gill, who was still on scene and pointed out by Ms. Southall. Officers immediately detained Gill for investigation. Gill stated he and Ms. Southall got into an argument at their residence, and as he was packing his things to leave, she approached him in an angry manner. He grabbed his firearm and placed it in his pocket. Gill stated he never pointed the firearm at her and nothing physical occurred. Paris stated when she and Gill were in an argument, he began to push and grab her. She stated that she was backed into a corner and was shielding herself in a defensive position. She told the children she was watching to go outside. At this point, Gill took his firearm out of his pocket and pointed it at her, stating he was going to kill her. Her mother witnessed the incident and recorded part of it. Officers saw footage showing Gill standing over Paris as she was cowered in a corner with Gill pushing and shoving Paris. The video also shows Gill following Paris outside while clenching something in his pocket. Portia stated that the gun he had was in his pocket, and Gill also pointed that gun at Paris, stating he was going to kill her. Officers received the gun from Gill, which came back as reported stolen out of Gwinnett County by Miss Peek People, PEEK-PEEPLE. When asked about the firearm being stolen, Gill stated he was given the firearm by one of Miss Southall's cousins, but he refused to give any further information. He was arrested on scene. And Your Honor, I have had an opportunity. I'm going to switch over one more time. I'm sorry. I've had an opportunity. Well, I reached out to Miss Southall multiple times. And it looks like the last time we were actually able to speak with her was at the prelim, but that was just back in April, or just before that prelim, back in April of this year. And at that time, She stated that she had no fear of the defendant. She mentioned that she didn't want anything to do with the case and would like to see it dismissed. She stated that the defendant had been going through a lot of grief lately as he lost various family members, and the two had been dating since November of 2024. She then mentioned to us that she did not want to be contacted again. I have attempted to contact her, but have not had any positive results from that attempt.
Okay, got it. Thank you. We have on the call from pretrial, hey, we got Mr. Howard. How are you, sir?
All right. First arrest.
This is the first arrest?
That's what I have.
All right. Well, easy GCIC for you to read through. Thank you.
Okay.
Ms. Rios.
Mr. Gill is 18 years old. He just turned.
Can you move the microphone towards you?
Yes, sorry. He's 18 years old. He just turned 18 last month. The reason why he's behind in school is because he was in custody. I was trying to get him out, but then they said they can't bond people out. We're under 18 for the bill project. So, but then finally his sister was able to get him out. But then by that time, he had missed a couple of months of school. So he decided to just go to the GED program. I think he's already signed up for that and is going to finish that way. He was arrested working at Smash and Eat as a dishwasher in East Point. He lives with his sister now. He does have family support, but I believe he lost his mom and some other family members. So he has been going through a lot. It's the first time he's ever gotten in trouble. So I'm asking that you accept the plea as negotiated and do a 1-year behavioral incentive fee. I don't think this will be a continuous thing. He's a really sweet kid, very nice. I think this is just going through a lot around this time.
Okay, got it. Mr. Gill, do you have anything you want to add to what Ms. Rios just said about your situation?
I just have like one question. So me taking probation. So I have to finish my 6 months out on my ankle monitor.
No. I'll talk about the ankle monitor. That can come off either late this week or early next week.
Okay.
Other questions?
No, Your Honor.
Ms. Southall, have you seen her since this situation happened?
No.
Good. You guys don't have kids?
No.
Nope. Do you have any kids?
Yeah, I have one little girl.
One little girl. What's her name?
Alani.
And does she stay with her mom?
Yeah, she stay with her mom.
How old is Alani?
She's like 9 months.
Oh, she's really little. Okay. Well, congrats. How often do you see her?
Like every weekend. Every 2 or 3 days.
Okay. And she's doing well. Healthy little kid?
Yeah, she's so chunky.
All right. Well, good. Tell me what Smash and Eat is.
It's like a soul food. Like they said a little bit of everything, like a soul food place. Like you got soul food, you got Caribbean food, you got Jamaican food, you got Indian food. Just everything put together in like a soul food restaurant. It's in East Point, but I was a dishwasher. Like it's a good restaurant.
Can you go back and work there when this case is over, or are you all done with that?
He asked about can I redo an application? He was like he want me back. He was like he willing to take me back.
Okay. All right. Good. Well, Mr. Gill, I find there's a factual basis for your plea. Sounds like you and Ms. Southall had some disagreement in April of this year. And I also find that your plea is knowing and voluntary. What that means is that you've understood what we've been talking about, and when you didn't, you asked a question. And voluntary means no one's forcing you to enter this plea. Do you agree with that?
I agree.
All right. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Rios, can someone in my office sign the indictment for you? Ms. Willingham?
Yes, Your Honor.
Mr. Gill, is it okay if we electronically sign your name indicating your first offender plea in this case?
Yes, Your Honor.
All right, real briefly about first offender. Ms. Willingham covered it. I just want to talk about it once more. You understand all these things I said about a conviction, they actually don't apply. If I sentence you as a first offender, it's not a conviction, which means if you try to go back to school, try to get a job, and there's a question on the application that says, are you a convicted felon? The answer is no, you're not. Today is not a conviction as long as you do well while you're a first offender. That's the good part. This can all go away after you finish your sentence. But if you mess up while you are on a first offender sentence, which you will be for a while, not only might you have new charges, but we would get back together and I might decide, you know what, Mr. Gill said he was going to do fine. He was going to get his GED. He was going to go work, take care of his daughter. And instead you're running around with a gun and making trouble. You could lose your first offender status and I could resentence you. And in this case, it's a bunch of years I could resentence you to. So I just need you to understand there's a risk to first offender as well. If you're going to get in trouble, then first offender is not a great idea. Do you understand that?
Yes, Your Honor.
Understanding that, do you still want to be sentenced as a first offender?
Yes.
Okay, well, I'll do that. Your sentence as to count one is going to be 3 years to serve 5 months. My look into Odyssey said we're shy of 6 months by about a month. So
Yes, Judge, and I think initially when I made the offer, I was under the impression we might have gotten to that.
we might have if it had been later on. So it's going to be 3 years to serve 5 months, credit for time served. Count two is the same sentence. Count three has to be 5 years, has to run consecutive. That'll be probated. And count four is 5 months to serve. So it's a total sentence of 8 years to serve 5 months with a balance on probation. Special condition number one is no contact with Miss Southall. So you got to leave her alone. Sounds like that's been happening anyway. But don't look her up, don't text her, don't do something with social media about her. Special condition number two, that address that we heard about on Greenbrier, was that her place or your place?
Hers, we were just living together. Well, I was just paying the bills.
Okay, but that was her spot?
Yeah, yes.
All right, you got to stay away from there. Don't go back there. Number three is that you got to get your GED, and you need to enroll in a GED program within the first 3 months of your probation. You may already be in one, but if not, you've got 3 months to get into a GED program. And you'll need to get your GED in the first 2 years of your probation. You'll need to do 60 hours of community service. That'll all be in your first year of probation. And you'll need to take an anger management course, and that you'll need to take within the first 6 months of your probation. So you're knocking all this stuff out early. I will set what we call a behavioral incentive date, which means if things are going well, probation can ask me to close your case out early. And I'm going to set that for October 2 of 2027. So 2 years from today. If you've gotten your GED, done your community service, stayed out of trouble, then you and probation can have a conversation about, let's get out of Mr. Gill's life. He's doing fine, taking care of his daughter, working, all that kind of stuff. I think those were all the conditions. Anything else, Ms. Willingham?
No, Your Honor.
Ms. Rios? Mr. Gill, you've got an ankle monitor. It was a condition of your bond. I will be signing probably today your sentence. It's called a final disposition. Ms. Rios will get that to you. That's what you need to take to second chance. You show them that document, they take your ankle monitor off. So as soon as you've got that document, you should get yourself to a second chance's office, wherever that is. Show them that document and they will remove that ankle monitor.
Okay.
All right. You have any questions about anything we talked about?
One question. Is y'all gonna send the information to my my Gmail?
What information?
About the ankle monitor part.
So Ms. Rios is going to get you your final disposition in whatever way she does it. She may to your Gmail, she may have someone hand it to you. I don't know. That's, she's real good at delivery, so she'll get that to you, okay?
Okay.
All right, we got one more piece. We have Officer Okuzu on the call. She is with probation. She's not going to be your probation officer, but she's going to give you reporting instructions. And these are important. You do not want to miss your first day of probation, okay?
Yes.
Good morning. Your Honor, would you like me to go out in a breakout room? I know we're recording live. I don't want him to give his address.
Sure, I'm happy to put you guys in a breakout room.
Thank you.
So, Mr. Gill, I'm going to slide you into a private space where you can talk with probation. She's going to give you reporting instructions, all that. Would you give us the reporting instructions now, though, so Ms. Rios can hear them? Because I bet she is going to reinforce them with Mr. Gill.
Okay, Mr. Gill, do you live in Fulton County?
Technically,
What's your zip code?
Yes.
30315.
30315?
Yes.
Okay, that's Fulton County.
All right. So you're gonna report on October 13th, okay? At 9 a.m. at the Atlanta DCS office that is located at 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. And that's where you'll do intake, okay? But we'll go in a breakout room and I'll get your contact information and your address.
All right, Mr. Gill, good luck with everything. Take care of your daughter.
Okay, thank you.
All right, hold on. Let me get these breakout rooms open. All right, they're done. Okay. Do we want to do Mr. Washington? Do you need to talk to Mr. Washington for a sec?
It's gonna be long though.
Okay.
That way you can get Jasmine out of here.
And Ms. Nix, I think. All right, 2 for 1. Is Ms. Wood back?
Yes.
And she returned to work?
Yes.
Okay. Great.
When I was at that other agency and I told them that I had never taken a week, like they were talking about how they took like weeks at a time off of work. And I said, in my entire career, I've
You've never done that.
taken a week off. And they were like, wait, what? I was like, how do you have time to take a week off? Like, I mean, even when I've taken off, it's never really been.
Your work follows you.
And
Yeah.
they were like, yeah, no.
So that might have been one benefit of being there.
That's, yes. Probably the only one in my.
Yeah. So you have the obstruction of law enforcement officers?
Yes, the criminal
Was the-
trespass. is-
Okay.
Yes.
Is your part, and then the registry is Ms. Nix's piece. Okay. All right. So we have new equipment in here that allows you to play video and audio with no lag. It's pretty exciting. Adam came in and tried it out. Was happy. You just plug your laptop in directly to some cabling that's now next to the podium. Should one of your cases ever go to trial?
Well, I have one that maybe, because I have 2 murders left in here now, so maybe. I remember my first case in here, I was talking through, well, the first one I tried first chair, I was talking through the video and had to eventually realize that the video and me were not
Out of
in
sync, yeah. So it feeds directly just to those? It feeds to all the screens, but there's no delay to these. So it's, yeah, so as long as you are narrating here, looking on your own screen or looking there, everyone, the important folks are seeing exactly what you're seeing and hearing it. Hey, Mr. Gill, what's going on? You're good to go. You can go. Bye-bye. Yep. Adios. Bye.
Oh,
Whenever I asked what the max is, was that name?
I was it was a live one.
No. Okay. I'm living at A, felonies, so A, what is what we have is.
1 to 5, the first second, then 2 to 10, third 3 to 2.
Yeah, that's, I agree with that. You just had to, like, we had a cheat sheet, A.
That's what I need, an Excel sheet.
Well, yeah, but you still have to look through the actual findings where there.
You just know what it is.
I made it
Are clear.
I can't keep up with them.
See, that's what I need to do. I don't have the time to do that. I need it.
But I still have to go look that up on all of those research, but like, because there's nothing new that we do,
Yeah.
you can't do it.
No. It's a patience.
I tried to ask ChatGPT to make one for me, and it was like,
Like, funny.
You would have had a lot to go back and check.
yeah, it actually did, like, but it was like, do you want me to keep going? And I was like, yes.
Yeah. You for AI.
Well, I didn't, I was talking to this feeling software. So he like, you have like, oh, straight on. Oh, yeah. And so he wrote on for me to like make it happen, but make it happen. So I really did, but I didn't actually cut him up with all that stuff, but just he would do like 20 of them. Good. So make it. I just just do them. And I would be like, you only got the fingers. You to wait before I see.
Okay, you can do it again. That's it.
Yes. That was fantastic.
Ms. Rios, are we good?
Yes.
All right. Should Mr. Washington come on up? Hey, Mr. Washington, come up to the podium, please.
Which case are we, how are we gonna do the pleas? Is one person taking you?
So I will ask one of the prosecutors to, other side of Ms. Rios, to do most of the litany. And then when it comes to factual basis and recommendation, for the casing in 019 is Ms. Nix's. And so let's just say hypothetically Willingham does most of it. Ms. Nix would chime in for factual basis and whatever the recommendation is for that case. I'm happy having either one of them do it, but we don't need both lawyers to say, do you understand that you have a right to a trial? Just need to do that one time.
And just like, I know probation's on and he shouldn't be on probation, or we're trying to figure out if he should, we're trying to see what's going on with his probation.
Well, let's find out. Officer Okuzu, is Mr. Washington, I can give you his case numbers. I don't know what you need to look him up.
Yes, if you could just give me one of the docket numbers, and I'm gonna
Sure.
have one of my colleagues look up the case.
Sure, it's 25 SC 003 019.
Okay, I should have information in a few minutes.
Great.
Mrs. Oak, I can give you one of the cases that I think you might be still on probation for. That's
Yes.
one of
Oh, that works.
Probation.
So I think he's still on probation for 23 SC 190985.
Okay, let me look that up in our system right now and see.
If it's not showing that he's already had a revocation, we would like to handle that too.
Okay. Can you give me that number again, Ms. Nix?
Yes, ma'am. Yes, sir. I'm sorry. 23 SC 190985.
Thanks.
And this is Raymond Washington.
Yes, ma'am.
Yes, he's currently on probation.
Okay. For just that case or multiple cases, or you're checking?
Let's see. It appears to be 2 cases. I have another docket number 23 SC 190984.
Oh, consecutive indictments. Okay.
And let's see. I could bring up the disposition and see what it's for.
984 is criminal damage second, and 985 is another registry violation.
Okay. So yes, he's on probation for 2 of those cases.
And how much remains?
The docket ending. Sorry. The docket ending in 984, the probation case ends 2/20/2029, and the other docket ending in 985 ends 2030.
Okay.
I got a question.
Yes.
Yes, Mr. Howard.
Is he still on probation for the fleeing an officer, habitual violator? Case number 22 SC 183076.
That one is showing inactive.
Okay.
It appears to have ended 5/29/2025, so it just ended this
Okay.
year.
Woo, just sailed in under that one. Okay.
Okay.
Mhm.
Thanks for flagging that, Mr. Howard.
Okay. It got the sentence date 11/30/2023 with 2 years, so that's why I was asking.
Yeah, well, he may have gotten somehow credit for, who knows, but they're saying it's closed out a couple months ago. Okay. Was there anything else you wanted to sort out before we dive in?
No, Mr. Washington, he's saying that the end dates are incorrect.
Yes.
Well, we can get to that. The bottom line is he's on probation, and so there is the potential of a revocation. Both those cases belong to Judge Whitaker. I'm happy to handle the revocations today as part of what we're working through. And so we'll navigate that at the appropriate time.
Before we get away from that, it looks like there was a revocation done 6/11/2025. So that that might have been for, I'm pulling that right out, might have been for the arrest and this.
Right, I'm sorry, I popped that up, but all I get is calendar notices. So like that was a hearing, but I don't have a revocation order. So notice was sent out to people that, in fact, Mr. Washington had a revocation hearing on the 11th, but I couldn't find any outcome. Officer Okuzu is there. Do you have in the system any probation revocation order from June of this year?
I'm showing one. I'm trying to pull it up. It's something about 44 days.
Oh, maybe it's in
I'm gonna try to
8-4 case. No.
It appears the state withdrew the petition on June 11th.
Oh, yeah. You may see, yeah, Judge Newkirk somehow covered it for Judge Whitaker. It says you all backed away from it. Okay. All right. So there has not been a revocation of the 223 SC cases on the basis of either sets of allegations that we're about to deal with. Okay. This is a lot of preface. Let's get started. This is 25 SC 003019 and 25 SC 004206, both cases involving Raymond Washington, who is here in court with his lawyer, Ms. Rios. The state is represented by Ms. Willingham on the 206 case and Ms. Nix on the 019 case. Mr. Washington, in a moment, who's doing the main part?
Judge, I believe it's going to be me.
All right, Ms. Willingham's going to put you under oath.
Yes, sir.
She's going to ask you a bunch of questions about your rights. We'll probably hear some from Ms. Nix as well, another prosecutor. I'll certainly hear from Ms. Rios and you. In the end, it sounds like the state's going to make one recommendation and your lawyer has a different recommendation. So it's a non-negotiated plea in part. I think one case it's agreed to, the other it's not. Whether it's negotiated or not, none of that binds me. And so ultimately, I'm going to say, hey, Mr. Washington, based on all this stuff, here's the sentence I'm going to give you. If the sentence that I impose is greater than what Ms. Rios asked for, you have the ability to say, no, thanks. I'd rather go to trial.
Yes, sir.
And so I'm going to give you two a chance to talk about it. It's not that I impose sentence and Deputy Gordon grabs you and runs away with you. You may end up saying is good, it's not good, but you'll have a chance to digest it.
Yes,
Ms.
sir.
Rios?
Yes, sir.
It's negotiated.
Okay, well, it's negotiated. It sounds like
Thank you.
everyone is agreeing on everything. But again, that doesn't bind me.
Yes.
I'm going to hear from everyone and I may think that that's crazy talk.
Sure.
And say, this man needs to go to prison for 10 years.
Sure.
And if I say 10 years and you're not interested in that and you think it's better to go to trial,
Yes, sir.
you'll be able to say, no, thanks.
Yes, sir.
Okay,
All right.
so we'll see how it plays out.
Yes, sir.
Anything else, Ms. Rios?
No.
Okay, Ms. Willingham, we're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Raymond Cordell Washington.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
41 and 11th grade, 10th grade, 11th grade.
So two things. One, make sure you let Ms. Willingham finish her question. It's not Jeopardy. You can't buzz in early.
Okay.
And if you talk over her, the court reporter has trouble typing everything. So you may know what's coming. This is not your first plea, but let her finish, hear that question mark, and then you can answer. You'll get as much time as you need to answer. Where'd you go to high school?
Punker P Central High School, Baton Rouge, Louisiana.
Baton Rouge. All right. Well, how long you been in Georgia?
25 years.
All right. Your new home away from home.
Yes, sir.
Ms. Willingham.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that in indictment ending in 3019, you are charged with state sex offender registry violation?
Yes, ma'am.
And in indictment ending in 4206, you are charged with willful obstruction of law enforcement officers by use of threats or violence. which is a felony, and criminal trespass and damage to property, which is a misdemeanor?
Yes, ma'am.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in both of these indictments, including any potential defenses?
Yes, ma'am.
And do you need any more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes,
Have you reviewed the indictments in both of these cases with your client?
yes,
And do you waive formal reading of the indictments?
yes,
Has your client been arrested on these charges?
yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants that are related to these charges?
No.
Do you understand you are entering a guilty plea to the following offenses in indictment in indictment ending in 4206? Willful obstruction of law enforcement officers, which has a minimum of
This is
no,
not a
willful obstruction
misdemeanor
is a
version.
felony.
He allegedly threw a bar stool at them.
Which has a minimum of 1 year and a maximum of 5 years. Criminal trespass, which has a minimum of 1 day and a maximum of 12 months.
Yes.
And I'm sorry, do you understand those?
Yes, ma'am.
And as to indictment ending in 3019, Ms. Nix?
State sex offender registry violation has a minimum of, because this is not, you have priors, has a minimum of 5 years and maximum 30 years.
Do you understand that?
Yes, ma'am.
And has your attorney advised you of those minimum and maximums prior to this plea?
Yes, ma'am.
Okay. And do you understand this is a negotiated plea of guilty, which means that the state recommendation to the court as to indictment ending in 4206 is as to the criminal trespass, 12 months probation, as to the willful obstruction, 3 years probation to run consecutive. Your Honor, my apologies. The way I have it written is count 1 is the criminal trespass. I'm not looking at the indictment.
Yeah,
I'm
the
looking at
indictment is
calendar.
felony first,
Okay.
then misdemeanor.
So it's backwards.
I had it backwards.
Yes, I did too. So I just wanted, that's why I'm saying the charges versus the counts. My
Okay.
apologies. As to count 1 then, 3 years probation. And as to count 2, 12 months probation. Count 1 will run consecutive then to count 2.
So a total of 4 years probation.
Yes, Your Honor. Is that what was explained to you?
Yes, ma'am.
And the special conditions of that indictment will be no violent contact with Ms. Bell, complete family violence intervention program, complete a substance abuse evaluation and follow recommendations, complete a mental health evaluation and follow recommendations.
Yes, ma'am.
And as to indictment ending in 3019, Ms. Nix?
Before we get to Ms. Nix, the special conditions were mental health evaluation and treatment if recommended, and then drug and alcohol abuse evaluation and treatment, just those two? Okay.
And then the complete family violence intervention program.
Oh, and FFIT,
Yes, and
Got
there's
it.
no violent contact with Ms. Bell.
no violent contact. This is the person whose door got beat up. Okay.
In 25 SC 003019, the state's recommendation is a 10-year sentence that you serve 4 months with credit for the time you've already served, and the balance to be served on probation. And the only condition is compliance with sex offender registry requirements.
And
And that's to run concurrently with the 4 years probation in the door and bar stool case?
Yes, sir.
Okay.
are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you do not accept the court sentence, you may withdraw your guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of willful obstruction of law enforcement officers and criminal trespass and damage to property in indictment ending in 4206?
Guilty under Alford.
How do you plead, and we'll go over the Alford plea in just a moment. How do you plead to the charge of state sex offender registry violation in indictment ending 3019?
Guilty under Alford.
How is it an Alford plea to a registry violation? This other one, he said, she said, you register, you don't register.
I can explain that. You want me to explain it now?
No, we'll get to it, but just, I want to make sure Mr. Washington may have just sort of thought, hey, I said Alford to one, so I should say it to the other.
So we've had ongoing discussions and I talked to, I'll jog your memory of this situation.
Okay, you, Ms. Nix, are, has your memory been jogged as to how there could be an Alford plea to a registry violation?
No.
No, okay, well, we'll get to it, and I can always say, look, I'm not gonna accept an Alford plea on that one, and we'll see what Mr. Washington wants to do, but let's press on.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with knowledge of all the charges against you?
Yes, ma'am.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if in indictment ending in 4206, the state would expect to show that on November 13th, 2024, officers responded to 1080 Ada Avenue Northwest, Atlanta, Georgia, in Fulton County. Upon arrival, they spoke with the victim, Ms. Bell, who advised that her boyfriend, Mr. Washington, was knocking on the door. She stated she refused to let him inside, in which he kicked the door in damaging the door frame. Ms. Bell stated she did live with Mr. Washington. Ms. Bell stated Mr. Washington is usually at the food mart at 1097 Hollywood Road Northwest. While checking the food mart, officers saw Mr. Washington at the counter. They grabbed Mr. Washington's arm, attempting to put him in handcuffs, in which he pulled away. Mr. Washington then grabbed a bar-style chair and threw the chair at the officers. Mr. Washington then ran out the store, in which officers were able to run after him, bringing him to the ground and place handcuffs on him. And as to victim contact, Your Honor, I've had an opportunity to speak with Ms. Bell. I actually spoke with her yesterday, and during my conversation with her, she emphasized that she felt like the defendant needed ample probation time, but that she also wanted no violent contact. She believes that the defendant suffers from mental health issues as well as substance abuse issues, and that if those things were taken care of, she says that he's one of the sweetest people when he's not under the influence or having a episode. So based on that, the state believes this is a reasonable resolution. She's obviously the listed victim as to the criminal trespass.
All right.
And
Ms.
Nix?
Ms. Nix, for our failure to register when he moved.
Yes, sir. Had this case gone to trial, the state would expect the evidence to show that on or about March 28th, 2025, the defendant failed to update his address when he moved from 1280 Nash Road. The defendant is a registered sex offender based on a 2005 conviction for rape in the third degree out of Louisiana. On March 28th, 2025, deputies did an address check for the address that the defendant had given as his address, which was 1280 Nash Road, and spoke with the current resident, who was Ian McGrath. Mr. McGrath stated that he had been a resident at that address since October 2024, and that the defendant, Mr. Washington, did not live there. In November of 2024, the defendant was arrested in an unrelated case, the domestic violence case that the defendant pled guilty to today. And in that case, the defendant was living at 1080 Ada Avenue Northwest, which is not 1280 Nash Road. The defendant never went into the Fulton County Sheriff's Office and updated his address from 1280 Nash Road, which he is required to do by statute, and that occurred in Fulton County.
You mentioned that Mr. Washington has at least one prior failure to register, and I think that's one of the two cases for which he's on probation. Is this his second or third or fourth? Where are we on that spectrum, if you know?
It's his fourth, Judge. He has two others from Clayton County, one from 2010 and one from 2014. This is actually his eighth felony, but it's his fourth registry violation. He is, however, currently registered. He did register when he was released from custody, as he is required to do, and that is why the state is offering this in this case, because our goal is to make sure that these defendants are registered. And since he is currently registered, that is why we're offering what we're offering.
And is he registered at Nash or Ada or yet another address? And you don't need to state it on the record. I'm just curious if it's one of those two or if it's yet another address.
It is another address.
Okay. All right. Thank you. Mr. Howard, tell me how many cycles you have for Mr. Washington and how many felony convictions.
Let's see. I got 28 cycles. Well, you know what? Hold on.
There's probably some in Louisiana as well.
Yeah, I think it was 2 out of Louisiana, so that should be 30, but let me check. Boy, hold on. It is 9 convictions, like state stated, though. I do have 9.
Okay.
Let me get this total real quick.
Deputy Gordon, is the prosecution screen on?
No.
No. Can you see if buttons help with that?
You don't have to do that.
You'll be gone by the time it works, but Ms. Rivers always likes to see the people who are talking. Pardon me?
You can see me on.
It's on now? Okay.
I've seen this name.
Hold on, let me see. Yeah, I got 2 cycles out of Louisiana. So that 28, that's 30.
Okay.
So 30.
And what do you have as the most recent arrest?
The most recent, let's see. I forgot to take that note for you. I'm sorry. Hold on. Is it the 2023rd? Hold on, let me see something. All right, hold on.
Your Honor, if I may, it looks like the most recent arrest would have been April 16th of 2025 from what I can see on the GCIC. And that was for.
Probation
this-
bios.
Yes.
Yep.
Okay. Thanks. And I'm confused, what probation violation it would have?
For the failure to register is what I actually have. So the actual arrest that I have on April 16th is for the failure to.
Oh,
register.
April, you said April, not August. I've got that. Okay. And he spent 86 days in, and that was related to whatever happened to Judge Whitaker, and then the state withdrew okay. All right. Got it. I think we are in a better place there, and look who joined us. It's next. Okay. Ms. Rios, what do you want to add here?
Yes, Mr. Washington is 41 years old. He works for statewide renovations. He's been doing that the last 20 years with his uncle. He has one 19-year-old son and an 18-year-old stepdaughter. He's currently living with his stepdaughter right now. And he did tell me he obtained a GED. And he obtained his GED. As far as the sex registry case, so I've talked to Miss Bell, this the victim, and the
Her door. She's not the victim from Louisiana.
No.
No, it's Ms. Bell's door that got abused.
So she actually sent me initially proof that she updated for him his address online. And I believe I sent that to Ms. Nix, but she updated it.
When he moved from Nash to Ada.
Yes.
Okay.
And so she had done it online, but I guess, and she sent where she tried to put it in. How they got involved, I guess she called them because they got into an argument and she was trying to get him in trouble. I don't know if you remember, we were on the Zoom and she was talking a lot and admitted that like, yeah, I was trying to get in trouble, and they fight back and forth. And so then they came out, and I guess they didn't realize it was updated online. And then whenever they went to that address, he wasn't there, but it was supposed to have been updated online. That's why this is an Alford plea, because he believed it was updated.
The registry part. Now, how about the kicking the door and not being compliant with the officers at the food mart? What's
I
the?
think it's more to kicking the door. Is that, than the food mart.
Okay, so you and the officers didn't have a good time together at the food mart. You're saying you didn't kick the door?
No, sir.
Okay, but not that when the officer said, hey, you need to come with us, you went in a different direction. Okay, I think I can navigate all that. Statewide renovations, what does that mean? You work on homes?
Yes, sir. Yes, sir. Remodeling homes, kitchen cabinets, countertops, tile floors, sheetrock, paint, stuff like that.
In Georgia, or do you ever go out of Georgia?
Sir, those are all in Georgia.
Okay, and right now you're staying with your stepdaughter?
Yes, sir. That's why when they gave me the ankle monitor, I had to go live with her because she paid the fine for me and stuff like that. And that's where my register address at.
What does she do for a living so that she can afford all this?
Worked at the Krispy Kreme Donuts.
Apparently you make lots of money working there. So she's, okay. But your ankle monitor is one that you're having to pay for, or it's from the county?
Yes, sir.
Okay. All right. And when did you get your GED?
Back in 2015.
Way back when?
Yes, sir.
Okay.
Yes, sir.
This case from Louisiana is a long time ago, 05.
Yes, sir. And all this just still over my head, like.
It is, that's the burden of the registry.
Well,
And
I've been trying to get, after so many years, after 20 years, it's been almost 20 years now. And it's supposed to come off my record and I don't have to do it anymore, but I got to go through so many cycles to get it off my back. And
you need to stay out of trouble in the interim. So
hallelujah on that.
one step at a time. Maybe you get a few years under your belt of no arrests, and then you could talk with a lawyer about how to get off the registry.
Yes, sir. Well, I ain't never been in this much trouble until I started dating this girl. I've been with her 10 years, and it just, if I don't come home on a certain time, she want to call the police and have me locked up. It's like she trying to be my mama, and I just don't go for it.
Okay. Well, last I checked, there are a few other women in Atlanta. So maybe you need to work through whether that situation gets you in trouble.
Yes, sir.
I'm not blaming Ms. Bell for anything, but you're a smart guy, and you now are old enough to know, hey, you just diagnosed it, is that you and Ms. Bell, it sounds like sometimes it's real good.
Right.
But when it's not real good, she may hop on the phone, 911, and you're the one who gets taken away.
Yes, sir.
Maybe it's not good enough for it to be worth that. And you need to figure out the right balance. I'm not telling you to stay away from her. She's asked for a condition of no violent contact, so you can be around her.
I don't want no contact.
Well, you can enforce that. You cannot take her call. You cannot, you know where she stays, but that's up to you taking those next steps. And you may feel a certain way, I need me some Bell time. And you may want to say, I'm not going to do that today, because then when she calls you next and you don't answer, or she looks in your phone, oh, who's this lady? Your phone's out the window, and next thing you know, you're in the back of a squad car.
Well, I want to know, how do I go with an officer to get my stuff from her house? Because she still have all my clothes and my tools and stuff like that.
At Ada?
No, sir. She's still somewhere else.
Wherever she is.
Yes,
your stuff is with her.
Yes, sir. She have all my stuff at her house. She never wanted to.
So first of all, you're allowed to have contact with her.
Yes,
so
sir.
you don't need my permission to call her to say, I need to go get my stuff. But
I want somebody to escort me, like, if I can be safe.
And so you should talk with Ms. Rios. There is a way to, you're last in line. Like, you don't call 911 to say, I need an escort, but you can arrange whether it's a sheriff's deputy or a police officer, and they're literally just keeping the peace. Hey, man, I just need you to roll up, park outside this house, because I'm going to get my stuff.
Yes, sir.
And it is doable. It's just not a real high priority, because police officers are wanting to get the guy who's running from them from the food mart, and not, I'm gonna help this guy get his tools. But there's a way to make it happen. Just ask nicely, and be patient. And that may be a good way to disentangle from Ms. Bell, if you're blaming her for all your arrests.
But she's trying to hold my stuff hostage because she want me to come back to her. And
and that's not okay. So you're going to need to figure out a way to work through that.
Yes, sir.
All right.
I think we got off. I was just gonna say it, or ask that you accept the plea as negotiated, and if you're inclined to, a behavioral incentive date.
Okay. Mr. Washington, I find there's a factual basis for both your pleas. I know you're entering it as Alford. You have got a defense.
Yes, sir.
And it maybe is a defense the jury would go with, but you know how this plays out. In theory, Ms. Bell could come in and testify, oh, he was kicking my door. And they might believe her rather than you. They'd say, oh, this guy's a sex offender and we're not going to believe him. You have some baggage that, unfortunately, as you talk about, it follows you around everywhere you go. And so that can make trial complicated.
Yes, sir.
I'm not saying I disagree with the Alford plea. I'm just saying that I think based on what Ms. Willingham and Ms. Nix told me, they could prove up their case. And a jury might side with them. And so you're saying I don't want to run that risk?
Yes, sir. Yes, sir.
And it sounds like the officers would be able to prove up that part.
Yes, sir.
About how you decided not to do what they asked you to do. I also find that your plea is knowing and voluntary. And that means you've understood what we talked about. You're a plenty smart guy. And unfortunately for you, you've been through this process before. And voluntary just means no one's forcing you to do it. You agree with that?
Yes, sir.
All right. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Rios, can someone in my office sign your name to both indictments? Ms. Willingham, can we sign your name to the indictment ending in 206?
Yes, Your Honor.
And Ms. Nix, can we sign your name to the indictment ending in 019?
Yes, sir.
And Mr. Washington, can we put your name on both indictments indicating that you're pleading guilty? Alford all the way to one, Alford to the trespass count on the other.
Yes, sir.
All right, we'll do that. Mr. Washington, I am sentencing you on 25 SC 003019. That's the registry violation, to a term of 10 years to serve 4 months with the balance probated. That's a whole lot of probation. You'll be able to shrink that down in a way I'm going to explain in a minute, but I, sort of like Ms. Nix, want to have that space to work with, because if we're together again in 6 months because you got arrested for pretty much anything other than littering, I'm probably going to revoke a bunch of your time.
Yes, sir.
You're 41, you know better, and you got to work harder to do better.
Yes, sir.
But if you get a few years down the road and there have been no issues, no arrests, you've been registering, et cetera, it may make a ton of sense to say, let's get this probation out of the way. Okay?
Yes, sir.
We'll see how that plays out. In 25 SC 004206, that's the door kicking, allegedly, and officer running from, not allegedly, case. Your sentence as to count 1 is 4 years to serve 4 months with the balance on probation. And your sentence as to count 2 is 4 months to serve. Those are going to run concurrently with each other.
Yes, sir.
And concurrently with your 10 years to serve 4 months in the registry case. In this other case, the door and the officer's case, you got a bunch more conditions. Condition number 1 is that you submit to a mental health evaluation. That just means you're going to meet with a doctor who's going to ask you questions about your past and how you feel about things, whether you've ever received treatment before. And if that doctor recommends that you get treatment, you're going to need to do that treatment. That might mean taking, and I'm making this up, this may not be you at all, taking antidepressant medication or getting some counseling. But if a doctor says treatment, that treatment is part of your probation.
Yes, sir.
Similarly, you're going to meet with an expert to assess you for drug and alcohol abuse. Do you drink too much? Do you smoke something you shouldn't be smoking? And if that person recommends any treatment, that treatment becomes part of your probation. So that person may say, you got to go to AA meetings.
Sure.
And you got to go to AA meetings. That's part of your probation. You will need to complete a family violence intervention program. That is a series of classes about how not to blow your stack when you are in an intimate relationship, so that if you get angry, you walk away rather than kick a door or swing your fist or something like that.
Sir.
You will need to enroll in the family violence intervention program within the first 2 months of probation. So don't kick that can down the road. No violent contact with Ms. Bell. That doesn't mean you need to contact her at all, but it means that if you do, she can't take a picture and say, hey, Washington's at my door, and get you arrested.
Sir.
That's not a violation of your probation. I'm going to waive your probation supervision fees for the first 4 months while you get back on your feet, hopefully working again. It sounds like your family runs statewide renovation, so you'll be back at it.
Yes, sir.
FVIP, the intervention program, that's not free, so you have to spend a little bit on that. So I'm going to waive your probation supervision fees for the first 4 months. And I will set a behavioral incentive date of October 2 of 2028. So that's 3 years from now.
Yes, sir.
If you have figured out a way to go 3 years, cold turkey, no arrests, no beefs with Ms. Bell, because maybe there's a new Ms. in your life, or whatever, then we can talk about, let's be done with probation. Now, that doesn't mean you don't have to register. You could be off probation.
Yes, sir.
You still may need to register. That's a separate legal discussion to have with someone. Any questions about any of that?
Yes, sir.
Okay, you doing all right?
Yes, sir. I'm good.
All right. That leaves probation. And if you are waiving any due process notice rights that Mr. Washington has, my proposal is to revoke I'm gonna make it 3 months of that time that he's been in, and close out those two cases so that Mr. Washington is on probation for these two newer cases. There's really not a purpose of being on probation for 4 cases. And so it would be as a result of these convictions in the 25 SC cases, revoke 3 months in each of the 23 SC cases, credit for time served, and close those out. We're going to have that 9 years and 6 months of probation from the registry case to work with if Mr. Washington, things don't go well in the next few years. Ms. Willingham, any issue with how I'm suggesting we handle probation?
No, Your Honor.
Ms. Nix?
No, sir.
Ms. Rios? Officer Okuzu, did that make sense, what I described about doing with the 23 SC cases?
Yes, Your Honor. I would just need a date to put on the revocation orders.
Sure. I'll give you 2 date ranges.
Okay.
One is November 13th of 2024
Okay.
through December 21st of 2024.
All right.
And the other is April 16th of this year through July 10th of this year.
Perfect. Okay. I'll get those orders over today for signature.
Thank you so much.
Thank you.
So, Mr. Washington, and one thing for Ms. Nelson, who's putting together your sentences. Your plea in the 019 case is an Alford plea. That's the registry one.
Yes, sir.
Your plea in the 206 case is Alford as to the misdemeanor, is not Alford as to the I didn't get along well with the officers. Okay? Officer Okuzu, what do you need to know about Mr. Washington? He's on probation and it's active. Does he need to report for the new cases? Does he need to call his officer? What's his next step?
He does need a report for the new cases for intake. I do believe we have an updated address. If I could just get his contact information and I can call him and give him reporting instructions.
Sure, we'll do that. What's the street name that you have for Mr. Washington?
Let's see. I have 330. Oh, sorry. I have Lincoln Street.
Lincoln? You're on Lincoln Street? Okay, I've got, you have lots of addresses. I've got a Brewer Boulevard and a Homewood Drive. Those are old. Can you stay in one place for a little while? Is this your daughter's place? The donut place. Okay, stay there. But whatever Officer Okuzu said, it's.
And in the future, I had talked to my probation officer. My goal is before Christmas to have my own place.
Okay.
So
Okay.
I can do my own thing.
That's all good. Just make sure when you're thinking about plunking down money for a place to have probation confirm that that's consistent with registry requirements. I know you know how that works because you've been registered for 20 years, but I hate for you to put down $500 for an apartment and then you realize, dang, there's a school 1 block away.
Well, I don't have no restrictions. Mine's is 0. I don't have no restrictions.
Okay, great. It is what it is. Don't tell me. I'm not the one telling you what they are. You don't want to mess it up. So just make double extra sure that you can stay. Having your own spot's great. Probably having a spot where Ms. Bell isn't is a good idea.
Right.
But you know the routine. You move, you got to tell the sheriff.
Yes, sir.
All right.
And my mistake, I did it online, me and her, and I don't want to do that ever again. Just go in person.
My advice, and I don't dole out advice, not my role, just go in.
Yes,
Just
sir.
hand someone the piece of paper. Here it is, Sheriff so-and-so, my new address, 1234 Main Street.
Yes, sir.
Don't risk the online, our system was down, and then here we go again. All right, Ms. Rios.
I'm sorry. When I looked at the dates, I said 4 months, but it might be 3 months that he was in. I might have been left off with that. I don't want him to get arrested again and have to do.
So it's more than 4 months, it's 135 days.
Okay.
So we're good. The only reason why, we're good.
Okay.
All right. Can you give a phone number to Officer Okuzu?
Yes, sir.
What is that?
45453-6119.
6119?
Yes, sir, 6119.
All right.
Okay, I'll call you shortly. Thank you.
Yes, ma'am, thank you.
She's gonna give you reporting instructions. Don't miss that date, okay?
Yes, sir, yes, sir.
All right. Any questions?
No, sir,
Good luck.
thank you.
Judge, may I be excused?
Yes, boy, Judge Barber's gonna kill me. Thanks, Ms. Nix.
Can I use the bathroom or do that?
Of course you can.
Yeah. You're getting it out.
Did y'all come up? Yeah. Sure. Cause a lot of he laid down. I was over there yesterday. About to finish. Oh, they all finished? Yeah, you know what it is. What's that guy with the older guy who had all the bags, so he still standing? Yeah. He was with brother yesterday. He was. What's up? I had a question. She was in bad, usually I see.
Judge, are we done?
You wish. No, sir. Ms. Rios just had to take a quick restroom break.
Okay.
I'll let you know. I wouldn't just leave people
Oh,
hanging.
okay. I didn't know. I was not sure.
Yeah.
Okay.
Hopefully we've gotten through the more complicated ones, but we'll see.
It was 6 total on the calendar, correct?
1, 2, 3, 4, 5, 6 people. Correct.
Okay.
Yeah, just the two of us. Your client had a question.
Who is here? Mr. Edmond?
No, the guy that's just at the plea.
Oh, he has a question. Okay. Everyone else is in custody. All right. Ms. Davis, what do you want to do first? Oh, come on. Express yourself.
Express myself? No, whatever, probably the hardest to the easiest.
Okay.
Whatever you get out of the way.
All right.
We do Mr. Lewis last.
Okay.
You do him last? Oh, that's probation.
Okay. We'll do Mr. Lewis last. Okay. Should we do Edmond next then?
Yes, there's 2 cases.
No?
Edmond, I just need to finish going over the waiver. I was doing that with Judge Kemp, everybody else is good to go though.
Okay, so just ask me what I want to do. I don't care.
We're gonna do Lewis last.
Okay, I think it would be quicker to do Willie Kemp because.
Oh, the drug work.
Yeah, because I
Okay.
have everything with it.
Let's bring Mr. Kemp out, please.
And my conversation with Edmond will only take 5 minutes.
Okay.
Sit at that. Sit at that.
Yeah.
You tired of me? Did you say that the last one? I don't think so. They could be making up stuff.
Okay,
I
I believe Gordon. Gordon doesn't lie. You said you don't, or you do? Okay.
Tell us what. Good morning, John.
Morning. Wait 1 second.
Yeah.
You need to plug in?
Yes.
You ready?
Yes, Judge.
Okay, let's get on the record. We have Mr. Kemp out here. Hello, Mr. Kemp.
Hello, John.
Mr. Kemp, you have 3 cases that I need to talk to you about, only 2 of which we're going forward with today. 23 SC 189057, it's a case you already pled to, and that's with me. And we're working through a revocation today on that. 24 SC 001849 is an aggravated assault charge. And yesterday, the state dismissed those charges. The person that you allegedly did something to, unfortunately, has passed away. And so the state can't go for, unrelated to whatever you supposedly did. And so the state cannot go forward with that. So they've dismissed that. So that one's off the table. And then we've got 25 SC 005198. And Ms. Rios, your lawyer, tells me that that's one that you're going to plead guilty to. With that plea and the revocation, everything's going on into drug court where you're going to get treatment. Is that your understanding?
Yes, Your Honor.
Great. For us to do that, Ms. Davis, who's the prosecutor, needs to put you under oath. And then she's going to walk through all the plea questions that you've done before. Do you have a question?
No.
Oh, you're just getting ready to raise your right hand. You know the routine. Let's go forward with the plea on 25 SC 005198.
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Willie DeMarcus Kemp.
How do you spell Willie?
Willie.
Okay, thank you. Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
46, and I graduated from Cedar Shores High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offense and accusation 25 SC 005198, theft by taking?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding this accusation, including any potential defenses?
Yes, ma'am.
Are you satisfied with their services?
Yes, ma'am.
Attorney Rios, do you waive formal reading of the accusation and any and all defects therein for the purposes of this plea?
Yes.
Mr. Kemp, do you remember being arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants related to this case? Mr. Kemp, has your attorney advised you of the minimum and maximum sentence for the charge to which you are pleading to today?
Yes, ma'am.
And this is a theft by taking valued at approximately $25,000. So it's a minimum of 1 year and a maximum of 10 years.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand that the court's not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge or on this charge?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess firearms while on probation?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at trial would? And that's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of a felony, which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9 and then ask you, do you understand, okay?
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in accusation 25 SC 005198 theft by taking?
Guilty, ma'am.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes that evidence would show that on April 23rd, 2025, officers were responding to 202 Cortlandt Street in Atlanta, Georgia, in Fulton County, where officers observed where there was a reported alleged theft of a motor vehicle. That vehicle was the property of Hertz Vehicles. It was a 2025 Toyota Camry that the defendant did not have authority from the owner for that property. Mr. Kemp took the vehicle from the lot without permission of the owners and then fled the location. Your Honor, this is
Was the vehicle recovered?
Let's see.
The restitution?
Let's see. There is not restitution. Oh, yeah, this would, just more specifically, Mr. Kemp was on the lot. There was an individual who was attempting to exit. He stepped out of the vehicle to tell him to leave the property. Mr. Kemp ran around him, entered the vehicle, and then fled the lot with the vehicle causing damage to the vehicle. They were able to track the location. They communicated that information to officers, and they were able to recover the vehicle. It was released to a Miss Snelling, I guess from Hertz. Your Honor, the state is recommending that Mr. Kemp enter the drug court program. We would be deferring to the court on the length of that sentence. But we have been in long talks with defense counsel about his probation revocation and some of the charges that he's been accused of stemming to drug and alcohol abuse. And so we're just deferring to the court for that sentence, but we're asking him to be accepted into accountability court.
Got it. Well, I don't decide whether he's accepted, but I signed some paperwork that made it look like he was accepted.
Sorry, sentenced. He is
Okay,
accepted.
got it.
And then as you stated for the record, for the other 24 SC case, yes, unfortunately, the victim did pass away literally about a week and a half ago.
Not because he got hit on the head with a bottle, unrelated. Okay. Okay, thank you. Hold on one sec. All right, Mr. Howard, what do you have for Mr. Kemp?
Got 47 cycles. 2003 possession of cocaine conviction. 2010 terrorist threats, criminal damage to property, 2nd-degree conviction. And just those open cases that I think you all just went over. That's all I got for felony convictions.
Okay. And most recent arrest?
He's been in custody since April?
Yep.
Okay, let me give you the one before that then. Before April was October 2024. Simple battery DV, possession of drug-related objects.
Okay, that's the basis of the revocation. Got it. Thank you, sir. Appreciate it. Ms. Rios.
Yes, Your Honor. Mr. Kemp is 45 years old. He has 3 children, ages 24, 18, and 15. He's been working at Blitz Movers. He did graduate high school. Right now, he is homeless, and he's been battling addiction for a very long time. So he was adamant since I first met him that he wanted to do drug court, and he thinks that that would end the cycle of addiction, and he's been accepted. So I just ask that you accept his plea into drug court and do no more probation than 5 years probation on that case. And then on the revocation, just revoke the time that he's been in.
Okay.
Probation, I mean. I'm not sure if I said probation. I said 5 years, but I can't remember.
You said probation, right? Okay, got it. Gotta look one thing up. I think that Ms. Simpson sent Mr. Kemp. Good. Okay. Mr. Kemp, you have one child who maybe is still in school.
Yes.
Boy or girl?
Boy.
Is he in the Atlanta area?
No, he's in Oklahoma City. But
with mom, dad, mom?
Yes, with mom.
Okay.
We've been trying to keep him in all type of sports and keep him out of gang-related areas. You know, trying to keep him on the right track.
Okay.
And
the 18-year-old, a boy or a girl?
Boy.
And where's he?
Oh, he's in Atlanta.
In Atlanta.
School teacher.
The 18-year-old is a school teacher?
Yes.
How is he a school teacher if he's only 18?
My bad. I'm saying my bad. He's 22 now. I'm sorry.
So you have
3 boys, yeah.
3 boys. The oldest does what?
The oldest is a school teacher. My 24-year-old, he died 2 years ago while I was
I'm sorry?
incarcerated.
Okay.
On that aggravated assault charge that y'all brought up.
Okay.
But yes, I have 3 boys.
Okay.
I'm just trying to get out to show them how to do better.
Okay. All right. Well, you got to take care of yourself first. That's the key. And that's where hopefully drug court will be helpful. Anything you want to add to what Ms. Rios had to say?
No, I just want to thank you for the opportunity to correct my wrongs and do right by myself and others.
Well, we'll see how it goes. Drug court doesn't have locked doors. You can walk away from it. If you do, then that's a sign that you need a different level of help. Drug court is non-custodial. It works real well for some folks, but for people whose addiction is too strong, then we have to graduate to a residential treatment, or if beyond that, even custodial treatment. But we'll try out drug court, and hopefully that'll help make a difference in your life.
Yes, Your Honor.
What drug or drugs do you struggle with the most?
Cocaine, Your Honor.
Powder, crack?
Powder.
Okay. Well, Mr. Kemp, I find there's a factual basis for your plea. Sounds like you hopped into a Hertz Camry and drove away for a little bit. I also find that your plea is knowing and voluntary, meaning you've understood what we've been talking about and no one's forced you to enter this plea. You agree with that?
Yes, Your Honor.
I'm sentencing you pursuant to the Probation Options Management Act. Drug court is, like I said, a great opportunity. I'm one of the drug court judges, just so you know. I don't want you to be surprised. There's a 50-50 chance that we'll be working together in drug court. But that's just a coincidence. It's not because you took a plea here. It's just that I'm one of the two drug court judges. So what I was about to say is I know from working with the drug court team, we are able to provide supportive housing for 3 to 4-ish months. Have you already told the drug court folks that you need that?
Yes.
Okay,
Yes.
good. You will be released on a Tuesday, probably next Tuesday, because that's enough time for them to be ready, provided they found a bed for you. And they will come get you from custody, take you to Hope Hall, which is where drug court is. It's right next to the jail. And then when you're done with orientation that day, you'll get transport to the supportive housing. It is up to you to come back to drug court the next day. They don't send a van to pick you up. They'll give you a MARTA card so you can get there. But that second day is for a lot of folks the hardest day because you're free, you're out. And that first night, some people say, I'm gonna go do something else. You're gonna have an ankle monitor on. Everyone in drug court has an ankle monitor the first 30 days. So either it's very easy for us to find you if you don't come back, or you cut it off, which is a felony, and you can get prosecuted for that. My encouragement to you is show up the next day, regardless of what you do the first night. You gotta invest in it. If you don't, we give folks a second chance, but it just gets more complicated. So having a relapse and using is not a reason to get kicked out of drug court. You just need to come in and be honest and say, life's complicated. I was in the neighborhood, those are my guys, and I used with them. And we don't celebrate that, but we work through how to make different choices going forward. But some people get into drug court and I think, uh-oh, I used last night, I got to cut and run. And you can, but it just means that when we catch up with you, we may have to shift to doing drug treatment courtesy of the Department of Corrections. And that is generally less productive. All right?
Yes, Your Honor.
Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes.
Ms. Davis?
Yes, Judge.
Mr. Kemp, is it all right if we electronically sign your name to the indictment indicating your guilty plea?
Yes, Your Honor.
I will sentence you to 6 years to serve 5 months with a balance on probation. You're going to get credit for the time you've already served. Special condition of probation number 1 is that you enter into and complete drug court. Special condition number 2 is that you stay away from all Hertz locations. If for some reason you end up with enough resources to rent a car going forward, it's got to be Avis or Enterprise or Dollar. But you and Hertz broke up and you can't be at a Hertz place while you're on probation. 10 years from now, go to all the Hertzes you want, but not while you are on probation.
Yes, Your Honor.
Because of this new conviction, I am going to revoke 5 months of your probation in 23 SC 189057, as well as because of your arrest in October of last year for simple battery and having drug-related objects. I'm not saying you did those things. I'm saying you got arrested for those things. That'll take care of your probation warrant. I'm reinstating the balance, so you're still going to be on probation in that case. And I'm adding a special condition to that probation, and that is that you enter into and complete drug court. So you're in drug court on 2 cases. The one you're pleading to today, the stolen Camry, and your probation that you had with me for false imprisonment and obstruction. So you got a lot riding on drug court going well. Anything else? I'm sorry, did you have a question?
Yes, Your Honor, thank you.
Okay. Anything else, Ms. Davis?
No, Your Honor.
Ms. Rios? All right. Officer Okuzu, anything you need to share with Mr. Kemp?
Being that he's going to go into drug court, we usually just put them in admin status, so he does not need to report to probation. But I would just like the dates for the revocation order that I would need to be doing for his probation case.
Sure. That is April 23rd through today.
Okay, perfect. All right, thank you.
You're welcome. So Mr. Kemp, you are all set. Drug court folks will come get you on a Tuesday. My guess is next Tuesday. If not, it'll be the Tuesday after that. It's just a question of they need to get your medical records and you may have already signed a release form. So you make sure you don't have tuberculosis, anything like that. And they need to make sure. Good. So then my guess is it'll be next Tuesday. All right. That's it.
Thank you, Your Honor.
Good luck.
Thank you, everyone.
Why don't you talk with Mr. Edmond to wrap that up? And then we'll do him, then Hatcher, then Lewis. All right.
This computer on, but the screen just showing.
It's like a lock screen.
Yeah.
Weird. Well, it shows you, so it's working. I mean, importantly, it's feeding, but we'll want it to. Oh, look at that! It's like this nice little wallpaper. For trial, I guess we don't need it for jury selection, but for trial on Monday, they'll need to make sure it's showing what's going on. Do we know yet who the new Miss Clark is?
No.
Okay.
I'll be the last to know. I'll know when they show up. Yeah.
You'll probably know before I do.
I doubt it.
You don't think so?
No,
Huh?
I don't think
Okay.
so.
Talking to, talking to her client. Okay. We ain't got nothing for you, bro.
You been eating all the candy. Hey, man, help yourself to our candy. You walk in here, fuss at my deputy and eat my candy. All right. There's a lot of sergeants in here.
Can you go assist in courtroom 5D into 12? Yeah, into 12 until you take lunch break. What happened? 5D, 5D. So, okay. Okay. I guess, I'm down to get contact. Let me call him, should do work.
Ms. Rios, are you ready to have Mr. Edmond come out?
Yes, sir.
Great. Ms. Davis, are you ready to go?
I am, Judge. I believe it's on the 10-9 calendar. Yep, I am ready.
Excellent. All right. Good morning, Mr. Edmond.
Good morning, how you doing?
I'm okay. How about you?
Fine.
Okay. Mr. Edmond, Ms. Rios tells me you're prepared to enter pleas in your two cases. Is that correct?
Yes, sir.
Okay. Ms. Davis, who's the prosecutor on your two cases, is going to swear you in a minute and ask you a bunch of questions. You'll need to answer those as best you can, and you should let me or Ms. Rios know if you've got any questions. Will you do that?
Yes, sir.
Okay, and make sure you speak up. And Ms. Rios, can you bend the microphone down towards Mr. Edmond a bit? Thank you. We've got two cases this morning with you. It's 25 SC 003-445 and 25 SC 004-469. Pleased to both those. Mr. Edmond, I don't know if these are negotiated or not, but regardless, in the end, your lawyer is going to be making a recommendation. If I follow that recommendation, then the plea is binding. If I impose a sentence that is more severe than what Ms. Rios asked for, you'll have a chance to talk with Ms. Rios about whether you want to accept that sentence or if you want to withdraw your plea. Today is what we call your final plea date, which is a time during which you could say no thank you if you don't like the sentence that I impose. I may well go along with what Ms. Rios says, in which case that's what you asked for. And so you're going along with it as well. But if I disagree with something and say, and I'm making this up, you know what? There also needs to be a fine of $1,000. You may say, that's not what I agreed to. I'd rather go to trial, in which case we'll get you back where you were and get you on the next available trial calendar. But you'll have a chance to talk with Ms. Rios about whether you want to go forward if my sentence is different. Okay?
Yes, sir.
All right, Ms. Davis, when you're ready.
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name for the record.
Joseph Edmond Jr.
Put your hand up.
Thank you. At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 36, 12th grade.
Did you finish high school or didn't quite?
No, sir.
Okay. Where'd you go to high school?
Washington, Booker T. Washington High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offenses? In indictment 25 SC 003445, possession of methamphetamine with intent to distribute, possession of a firearm during the commission of a felony, willful obstruction of a law enforcement officer, reckless conduct, use of a firearm by a convicted felon during a crime, and firearm by a convicted felon. Do you understand that?
Yes, ma'am.
And then do you understand that in 25 SC 004469, you're charged with possession of a methamphetamine with intent to distribute, possession of a firearm during the commission of certain felonies, obstruction of a law enforcement officer, battery, simple battery, fare evasion, and use of a firearm by a convicted felon?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to the charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you in both indictments, including any potential defenses?
Yes, ma'am.
Are you satisfied? Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Attorney Rios, do you waive formal reading of both indictments and any and all defects therein for the purposes of this plea?
Yes.
Mr. Edmond, do you remember being arrested on these charges in both cases?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to these cases. Attorney Rios, are you aware of any outstanding warrants related to these charges?
No.
Mr. Edmond, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
Okay, and I'm going to go through those in 1 second. I want to pull up the indictment to make sure.
Give me 1 second too, please. I got it. All right. Okay. I found it. All right.
Okay. I'm going to start with indictment 25 SC 003445 for possession of a methamphetamine with the intent to distribute. For that is a minimum of 5, maximum of 30 years. For possession of a firearm during the commission of a crime, it is 5 years consecutive. For obstruction of a law enforcement officer, because you were just resisting arrest, it is 12 months. For reckless conduct is 12 months. Possession of a firearm by a convicted felon is 1 to 10 years, and there's 2 counts on this indictment.
They're different, and so I don't know that the ranges are the same. They're different statutes. So I can look those up while you're pressing on, but I don't think it's the same range for both.
Well, Judge, it was my intent just to null pros one. I think they did it the same. The person who indicted this did it in both cases, and I was going to.
You can no pros whatever you want, but one of them is, hey, you possessed a firearm and you've been convicted of a firearm offense before. And that's a different offense from the last count, which is you were a felon and you had a firearm. So I don't know that the ranges are the same, but if you're null prosing one, I just need to know which one you're null prosing.
I'm moving forward with the standard 131.
Okay, so you're null prosing count 5. And then count 6 is 1 to 10. Understood.
And then for indictment 25 SC 004469 is the same range for the possession of a methamphetamine, 5 to 30 years. or the firearm to the commission of a crime is 5 years consecutive. Obstruction of a law enforcement officer. Also 12 months 12 months maximum for the battery, 12 months simple battery, the same. And this one, I'll be moving to no pros count 8. I just need to get clarity on the fear evasion.
That's a misdemeanor.
Yes, so 12 months.
Okay. So count 8 is null pros, and then count 9 is the 1 to 10.
Yes, Judge.
Okay.
That was a lot. Do you understand everything that we were saying about the maximum possible sentence for each charge to which we described?
Yes, ma'am.
Okay. Do you understand that today you are entering a non-negotiated plea or a blind plea? This is where the state will still make a recommendation to the court.
Yes, ma'am.
Okay. Do you understand the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
And then the judge already explained to you that you have the right to, at this stage, withdraw the plea if you are not in line with the sentence imposed.
Yes.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you would be guilty of a felony which can carry a sentence from 1 to 15 years in prison.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9 and then ask you, do you understand? Okay. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal these guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 25 SC 003445, possession of methamphetamine with intent to distribute, possession of a firearm to the commission of a felony, willful obstruction of a law enforcement officer, reckless conduct, and possession of a firearm by a convicted felon?
Yes.
How do you plead to indictment 25 SC 004469, possession of a methamphetamine with the intent to distribute, possession of a firearm to the commission of a felony, willful obstruction of a law enforcement officer, battery, 2 counts of simple battery, fair evasion, and possession of a firearm by a convicted felon?
Yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show at trial that in indictment 25 SC 003445, The officers with the Atlanta Police Department were surveilling the area of a package store in a high crime area. That location was 842 Ralph David Abernathy Boulevard in Atlanta, Georgia, in Fulton County. Officers were using the Fusus camera system, where it's the surveillance camera footage. They were able to observe a male conducting multiple hand-to-hand drug transactions. He also lit a firework and threw it on the sidewalk where pedestrians were walking. Officers approached him, attempted to detain him, but he resisted. That individual was identified as the defendant, Mr. Joseph Edmond. Once they were able to handcuff him, they placed him in the patrol vehicle. They did also locate on his person a Glock handgun in his waistband. A search of his backpack yielded a large amount of marijuana and suspected MDMA pills. It was confirmed by the GBI that they were actually methamphetamines, and it was 5.8 grams. The marijuana was not tested. In indictment 25 SC 004469, officers with the MARTA Police Department, and this occurred, on December 29th, 2023. Officers with the MARTA Police Department observed what they believe was an assault between the defendant, Mr. Joseph Edmond, and I believe at the time his girlfriend, Mr. Derkaya Hall. Basically, they were at the West End MARTA station, and this is located at 680 Lee Street. They observed him on camera, those two getting into an altercation. It appears that the defendant spit in her face. She hit the defendant. The defendant then slammed her to the ground and punched her. He clutched something which appeared at the time to be a weapon, and then officers attempted to respond pursuant to that incident. Ebola was sent out to all officers with pictures of the defendant. And on January 8, 2024, they spotted him at 832 Ralph David Abernathy Boulevard in Atlanta, Georgia, and Fulton County. They attempted to detain the defendant based on this incident. He attempted to leave by jumping on a scooter and then running on foot. They were able to detain him. They also located at that time a handgun in his waistband, some MDMA pills, also some marijuana as well, but the GBI did test those pills and confirmed they were methamphetamine, weighing 5.5 grams. Our recommendation for the court originally was for a 10-year sentence, for 5 of those years to be served in custody, the balance on probation.
When you say originally, are you going to say a different sentence now, or that's still your recommendation?
That's still my recommendation.
Okay.
I did say originally, Judge. Originally and currently.
Okay.
For the defendant to serve 5 years in custody, balance on probation, drug and alcohol evaluation and treatment if required, for him to complete his GED or provide proof to probation, complete 60 hours community service, forfeit all firearms, have no contact with the victim, and to stay away from all incident locations.
All right. Have you had any contact with Ms. Hall or someone in your office?
I have not personally, and I just want to triple check and see if anybody from our office was able to reach her. I don't have that we've made contact with the victim.
Okay. Got it. Hello, Ms. Smith-Mann. We swapped out personnel from pretrial. Appreciate the coverage today. Have you had a chance to run Mr. Edmond's criminal history?
Yes, Your Honor, I have. What I have before me is 43 cycles. Last arrest was 2024 FTA 2007 felony obstruction convictions. And Your Honor, these will all be felony convictions. 2008 felony obstructions, 2 counts. 2009 robbery, felony obstruction. 2010 sale of marijuana. 2010 sale of marijuana. 2012 theft by receiving stolen property, forgery, second degree. possession of a firearm by a convicted felon, sale of marijuana conviction, 2012, sale of marijuana, 2015, theft by taking, possession of firearm by a convicted felon, and 2016, possession Schedule 2 conviction. Nothing further, Your Honor.
All right, thank you so much.
You're welcome.
Officer Okuzu, is Mr. Edmond on probation for any of those cases still?
No, he's currently not on probation, Your Honor.
All right. Ms. Rios.
Yes, Your Honor. Mr. Edmond is 35 years old. I'm 36 years old. He was working at long service, self-employed, so he's been on and off with employment. He has a drug problem. I have gotten him into the Salvation Army program. I have an acceptance letter for them. He wants to change his life and do well for his children. He has 5 boys and 1 girl and 1 grandchild. One of his sons passed away while he was in jail. I believe I sent Ms. Nelson the obituary for his son. And so he wants to be able to be there for the children that are living and make a change. I know based on his history, it looks like a lot of it was selling, but it was supporting a habit. He does have an addiction issue. So I'm hoping with the rehabilitation program that he will be able to kick this habit. His drugs of choice are meth for the most part. So for case 25 SC 003445, I'm asking for count 1 to be 10 serve 8 months, count 2 5 years consecutive, count 3 12 months, count 4 8 months to serve, count 4 8 months to serve, count 5 was all crossed, and then count 6 10 years serve 8 months. And then on 25 SC 004469, I'm asking for count 1 to be 10 serve 8 months, count 2 5 years consecutive probation, count 3 8 months, count 4 8 months, count 5 8 months, count 6 8 months, count 7 8 months, count 8 is now processed, and then count 9 10 serve 8 months. So total of 10 serve 8 months with the 5 years consecutive probation.
Okay. Mr. Edmond, anything you want to add to what Ms. Rios has already shared with me?
Yes, I'm asking for the mercy of the court because, you know, my child died in February and, you know, that made me feel like, you know, like it made me feel real bad about it. Like I wasn't even there to be there. I was in jail just because of the bullshit that I do, just for a habit, just to get drugs. You know what I'm saying? And you know, I have more kids that need me. And my daughter, she trying to go to college, and she need me. And I just wanted to change my life around, and I never had help doing that. Nobody never helped me, period. Try to, you know, change my life. I always get in, get out. You know what I'm saying? I never had a program. I never, you know, been in a situation where I could help me and myself so I could help my kids. You know what I'm saying? And it just be hard. It's depressing. And, you know, it's pitiful. So I'm just asking for the mercy of the court. Like, it just, you know, at least just deal with me one more time.
Okay.
Well,
I appreciate you sharing that, and I'm glad you're realizing how the choices you've been making, and it sounds like it's often driven by addiction, not that you're willfully making those choices, are destructive for you and for your family. You mentioned you've got a daughter who's trying to go to college. How old is she?
She's 17. She has my grandson.
Okay, so she's in high school now?
Yes.
She a junior, a senior?
She's in 10th grade.
10th grade? Okay. And she's the one who, she has a kid and that's your grandkid?
Yes.
Okay. Who does she stay with to help her manage things?
She stays with her boyfriend
Okay,
right now at the moment.
got it. And is the boyfriend the father of the child?
Yes,
So they're together as a family?
yes.
Is your daughter still in school? Is she able to stay in school?
She's working, but she's trying to maintain right now.
Sure.
Because she don't have no help.
Got it. Does the boyfriend work?
Yeah, both of them work.
Okay, so they're both working to try to keep their household going.
But the grandma, the boyfriend's parents been watching them and they've been complaining. So it's just like, I'd rather just help her.
Sure, I bet you want to be there to help.
Yes.
Is that daughter your oldest child?
No, my oldest are 19.
Okay, boy or girl?
19 boys.
Well, do you have twins?
Yeah.
Okay, are they out of school?
They're out of school. They're on the way to college. They just graduated this year.
Good for them. Where are they going to college?
One of them said Auburn, one of them going Georgia Tech.
Okay, well, that's good stuff. And how young is your youngest?
My youngest is 9 years old.
Okay.
And my other youngest was 5 who died.
The one who passed away was 5?
He died in February.
Okay. I'm real sorry for your loss. That must have been difficult to be locked up when something like that happened. Well, Mr. Edmond, I find there's a factual basis for your plea in both cases. They're kind of similar, drugs and guns. Ms. Hall, is she still someone in your life that was a one-time girlfriend, long-term girlfriend?
Yeah, she's still someone in my life.
Is she the mother of any of your kids?
No, she's just my girlfriend.
Okay. Does she have an addiction problem?
Yeah.
Okay. Meaning if you spend time with her, you both might use?
I'm not going to be with her when I get out.
Okay. You're done being with her?
Yeah.
All right. Have you had contact with her since you've been locked up?
No.
I also find that your pleas are knowing and voluntary, and that just means you've understood what we've been talking about and that no one's forcing you to enter these pleas. Do you agree with that?
Yes.
Any questions about anything so far?
No, sir.
All right. I'm sentencing you pursuant to the Probation Options Management Act. Ms. Rios, can someone in my office sign the indictments for you?
Yes, Your Honor.
Ms. Davis?
Yes, Your Honor.
And Mr. Edmond, can someone sign your name electronically indicating your guilty plea in the two cases?
Yes.
All right. So, Mr. Edmond, I'm hearing you and feeling your plea to be given another chance to be there for your family, et cetera. And it's not falling on deaf ears. But I also see sort of where you've gotten yourself, whole lot of arrests, serious number of convictions. And then we've got, it was almost an anniversary in January of 24 was you getting arrested with drugs and gun. And then a year later, January of 25, and it was really only, it was also on Ralph David Abernathy's, like a block away. Similar drugs, gun, and that's dangerous for you. It's dangerous for the people around you. And we need to come up with a hard stop. I'm not confident that Salvation Army is that hard stop. I'm going to come down somewhere in between what the state's recommending. I understand where they're coming from on this and what Ms. Rios is recommending. So hear me out, and then you and Ms. Rios can talk about it. And like I told you at the beginning, you can say, I can't do that, and we can get you a trial on one or both of these cases. So what I'm going to do overall, I'm going to give you the number, and then I'll tell you how we break it down. But I'm going to give you the overall number so that you and Ms. Rios can talk about it, about whether it's something that you even want to do. My sentence that I'm going to impose is 10 years to serve 3 years with the balance on probation. You'll get credit for all the time you've been in. There's no recidivist notice that I see, and so I think your convictions are parolable. And then I've got some conditions about getting your GED and things like that. But the biggest difference is Ms. Rios was asking for a sentence that will get you out in the next few days to Salvation Army. The state was saying 5 years to serve. I'm saying 3 years to serve. That's more severe than what Ms. Rios asked for. And so today you can say no thanks, and we'll make sure you get onto a trial calendar. You'll stay right where you are until that trial calendar. Or you can say, you know, it's not what I was hoping for, but it's what moves my cases forward. And I'll be recommending that while you're in custody, you get to do the residential substance abuse treatment program within the Department of Corrections, which if you complete, gets you out a little earlier. But that's a decision they'd make and that you'd make with them. So why don't you two talk about 10 Serve 3 versus Salvation Army? And then you can let me know if that's something you want to go forward with. And then I can break the sentence down into all the little pieces that it'll have.
Yes.
All right?
Judge, we would like to move forward with the plea.
All right. So Mr. Edmond, you and Ms. Rios had a chance to talk. She's telling me that you want to move forward. Here's how your sentence is structured in 25 SC 003-445. Your sentence as to count 1 is 5 years to serve 3 years, balance probated. Count 2 has to be 5 years and has to be consecutive. I'll probate that. Counts 3 and 4 are both 12 months to serve. They'll be concurrent with each other. And count 1, 5 is dismissed. And 6 is 5 years to serve 3 years, concurrent with count 1. Total sentence of 10 years to serve 3 years, balance probated. Special condition number 1 is that you complete your GED. You can do that while you're in custody. They make that pretty easy. If you don't, it'll be something you need to do while you're on probation. I'm not going to include any community service. When you get out, you should focus on plugging back in with your family, getting back to work, et cetera. You will forfeit the firearm that was seized in that case. That's it for the 445 case. Your sentence in 25 SC 004-469 will run concurrently with your other one. So everything's running at the same time. Count 1 is 5 years to serve 3 years, balance probated. Count 2 is 5 years to serve. It has to be consecutive to count 1. Counts 3 through 7 are all 12 months to serve. They'll run concurrently with each other and with count 1. Count 8 is dismissed, and count 9 is 5 years to serve 3 years, concurrent with count 1. So again, we've got a 10 years to serve 3 year sentence with those same conditions of get your GED, forfeit the gun. But that one has the added condition of no contact with Ms. Hall. So when you're out and on probation, you need to stay away from Ms. Hall. Sounds like you've already made that decision, but that'll be part of your probation. And I'm going to add language in both sentences that recommends to the Department of Corrections that you participate in their residential substance abuse treatment program. which I think will be super helpful if you get into that. You will get credit for all the time you've already been in custody. That will go towards your overall sentence.
So that will count toward my parole too?
Yes, sir.
Okay.
Right.
So how am I, what percentage is parole? Like,
I don't know how that works. I intentionally stay out of that mix because judges don't have any say in parole. What I can tell you is my limited understanding is it's based in part on the seriousness of the offense. And these are viewed as only medium serious. You didn't hurt anyone. And the extent of your criminal history. That's a little bigger, so that might move you in the grid a little bit. But if you had shot someone, you're going to do a whole bunch of your sentence. If what you had done was break into someone's car, you do less of your sentence. I think you're in that direction, but not a decision I make. And they don't even ask me my opinion. So I don't get to tell them, hey, Mr. Edmond is a good guy who wants to be with his family.
So would I go to level 5 or I ain't never been to prison.
You will go to Jackson first. That's the diagnostic facility. Everyone goes there, and that's where you will meet with counselors. They'll figure out, this doesn't apply to you. Are you in a gang? Because if you were, you can't go to this facility because that's where they send these guys and that. They'll look at what your needs are, substance abuse treatment. That'll affect where you go. The length of your sentence. It's only, I put that in air quotes, 3 years is a long time, but it's 3 years. It's not 30 years.
Yes.
They'll look at what your conviction is. It's not robbing someone at gunpoint. That's going to get you into higher security than you have an addiction. And so you're selling little drugs and you're using drugs. That's lower security. Now, if you show up there and break the next guy's nose when you're there because you punch him in the face, they're going to put you in high security. Some of it you control by staying in your lane while you're at Jackson. But you start there, you meet with counselors, and they figure out where is the safest place that best fits your needs.
Yes.
Okay, I don't know about these levels you're talking about, but you are not going to Supermax. That's not who you are.
Yeah, okay. I never been to prison. That's why.
Okay. Well, I'll tell you what. My hope is you don't like it there, because that'll help you when you come back and plug in with your family. Say, I'm going to take the steps I need to not go back there.
Yes, sir.
All right. Anything else?
That's all.
Good luck. Sorry for your loss. Thank you, Ms. Rios.
Sorry, Your Honor, if I could just get reporting.
Hold on 1 second, Mr. Edmonds. I forgot. This is probation, and they're going to tell you something. You'll hear about this again because probation and parole are run out of the same group. But just in case you didn't get parole, Officer Okuzu?
Yes, so it's just simple. Once you get released, Mr. Edmond, we do need you to report to the Atlanta DCS office located at 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. Within 48 hours upon your release, and that's where they'll do intake with you. Thank you.
And you don't need to memorize that address. You'll be told that again when you're being processed out of wherever you are. You may end up, because of your situation, at the reentry facility, which is just across into DeKalb County. And they would tell you the same thing about where and when you need to report to plug in with probation.
Yes.
Okay?
All right.
All right. That gets us to Hatcher.
Judge, can you check Teams, please?
Yes, ma'am. Would require me to open Teams. Nope, it's open.
Someone online for Hatcher. You have your YouTube up or
3445.
Zoom? Am I on Zoom? Mm-hmm. Oh. There'll be a family on there.
Counts 3 and 4 are 12 months to serve.
It's for Lewis.
And 6 is 5 years to serve, 3 years balance probated. And both those run concurrently with count 1.
Thank you.
You're welcome. Sorry, I was talking too fast, trying to be like Ms. Davis. Is that your tooth?
Candy.
Candy. It's running low. We got a trial coming up. We have to refresh.
The good is the whole premise of the case.
Hatcher.
I got a whole premise. The whole premise is the good. Thank you. He said it was no good, as well as you know. He said it was no good. He said it was no good. Lies. Lies.
Hey, Mr. Hatcher.
Hey, how you doing?
Good, how are you?
Bless.
All right, let's get on the record, Mr. Hatcher, with your case. Good morning, I'm Judge McBurney. Your case is 25 SC 005-405, and we are here, I think, just to talk about bond reduction. You were given a bond in June, about 4 months ago, by Judge DeFore, $22,000 bond. Based on the charges you had then. Don't know if you still have all those charges. Let me see what the indictment says. Yeah, so you only, 1, 2, 3. So I think it would mean you now have a $20,000 bond because there were 4 charges when you got your bond. The state dropped the 4th count. So I think that means you'd only need to post 20,000. Either way, no contact with Ms. Rochelle, stay away from an address on Conley Road, no weapons. That is where we are. Ms. Rios is going to tell me why that bond should be reduced. I'll hear from Ms. Davis, who's the prosecutor who has your case, at least right now. I don't know if this is a case that will be in one of the specialized units, but Ms. Davis can certainly handle the discussion about bond reduction, and then I'll let you know what I'm going to do, okay?
Yes, sir.
All right, Ms. Rios.
Yes, Your Honor. Mr. Hatcher is 34 years old.
Is how old?
34.
Okay.
And he has 3 children, ages 16, 9, and 6. He says he has his real estate license. So, and he was currently attending, right? George, he's currently attending Georgia State for engineering. I'm asking that his bond be reduced to 10,000. He will have an address. He has somewhere to live. He is, I believe, has a wife and children. I think she should be on. I know I spoke with his dad also, and they both should be on the Zoom in support, but he has family support. He just can't afford the $22,000 bond.
So I've got an address of Spruce Circle. Is that where you would go, or that is yet another address?
That is my dad's address.
Okay.
I have a different address to give you.
Okay, we'll get to it, but that's what's in the system that's your dad's place. That's not where you plan on going.
No,
Okay, where you plan on going, is it a house or an apartment?
it's a house.
Okay, and that's where your wife and kids are, or that's a different place?
Yes.
And your wife is not Alante Rochelle?
No,
Okay, who's that?
I don't know who that is.
Okay, don't go any further than that. I just wanted to know that's not someone you're supposed to stay away from as a result of these charges. Let me look at the indictment. Alante Rochelle. Okay. So $10,000, stay at this place. Do all 3 of the kids live at that household?
Yes.
Okay. Does your wife work?
Yes.
What does she do?
She's right now. I talked to her. She's doing security right now.
Okay.
But she also has a real estate license as well. So
It's a household of realtors.
yes.
Are you affiliated with an agency?
Yes.
What agency is that?
Coco Capital.
When you were booked in, you listed Austin Hatcher as your emergency contact.
Yes, that's my older brother.
Why wouldn't you list your wife?
Because my wife was in here with me at the time.
She was in custody also?
And they had locked her up.
In connection with the same situation? Oh my gosh, okay. She's not in anymore?
Not in anymore.
Did she get indicted?
No.
Okay. What's her name?
Jessica Bush.
So that wouldn't be a great contact if she was in custody. Did you get literally arrested at the same time?
Yes.
Huh. So she's out now and is with the kids.
Yes.
Jessica Cherie Bush?
Yes.
Or Sherry?
Yes.
Okay. All right, this is gonna be an interesting case. Okay. How long have you been enrolled at Georgia State?
For 4 years.
For 4 years.
My last year, sir.
Okay. Ms. Davis.
Judge, we'll defer to the court on if the court is considering a reduction. Mr. Hatcher does have previous felonies. They're about 10 years old, though. I did file a recidivist notice in this case. I do believe the bond is fair and appropriate as it is. It's pretty low based on the allegations, but we'll defer to the court.
Okay. So you've been in for over 100 days now, not able to make that bond.
No, sir.
Okay. I can't tell if there's a hold. It says foreign county. Are you aware of, do you have business in some other court?
Just in Clayton County, but it's just for a misdemeanor that was 4 years ago.
Okay. But they want you down there?
I don't know if they want me down there. When I talked to the Bells Bomber told me that they might not even come and get me because the case is so old.
Okay. Ms. Nelson, are you able to tell if there's a hold, or is that a Deputy Gordon project?
Let me look right quick, Judge.
Thanks.
Your Honor,
Yes, ma'am.
I have that it's an active warrant in Gwinnett, I believe.
Okay.
That's the possible foreign county hold.
Okay.
Okay. I don't know what that's about.
I'm asking Mr. Hatcher just because my preference is always, let's get you to that other jurisdiction, figure out what that situation is, bring you back here, and then if there are no holds, we could talk about what to do about bond. But if you do have a hold from somewhere else, if you put up the bond money, all that means is that you're going to be shipped to Gwinnett or Clayton or wherever. But I can get you there. We can release you to a hold and then bring you back here. In the meantime, Ms. Rios has already filed a waiver of an arraignment, so I can get a scheduling order in place and we can be moving your case along so that Ms. Rios can start talking with Ms. Davis and with you about, is there a way to resolve the case? But I need to sort out if there's not a hold, then we need to figure out what to do next. But I could give you a $1 bond and you wouldn't be getting out because of the hold.
Yeah, that's understandable. I just want it to be lower than what it is now. I could go ahead and go to the other counties if I just bond out here and handle that.
That's one way to deal with it. I need to figure out what the holds are, and then we'll figure out, do I send you there and leave this bond in place till you come back? Or do I lower the bond here, which results in you then going there?
Yes, I would like the bond lower than me results in going there.
I understand what you're asking for.
It looks like it's a Clayton County hold, no bond.
Okay, all right. So Mr. Hatcher, what I'm gonna do is take Ms. Rios's motion under advisement. And I'm gonna find out if Clayton, if we can get you to Clayton without messing with the bond. But if I need to, then, well, let me ask you one more question. Have you been unable to post the bond, or has no one been willing to post it because you have a hold for somewhere else?
I wasn't able to post it because my wife was locked up.
Okay,
The bond was still too high for us. All my property and everything with my cars are at the annex building. So she really doesn't have nothing, access to none of our money right now.
when did she get out?
But she's already out. She got out August 26th.
All right, so she's been out for a month plus now.
She's supposed to come up here Thursday to come get my cars and everything. So
When you say come up here, where,
annex building,
right, but where is she now? What town is she in?
she's in Forest Park.
Okay, got it. So she'll come get your stuff. She can get into bank accounts, et cetera. Where were the kids when you guys were both locked up?
My kids was in Florida. They was with their auntie.
Okay, but the 3 kids are the kids biologically of you and your wife?
Yes.
Okay, but when you got locked up, auntie came to get them?
They was already in Florida for summer because this happened summertime.
Okay.
So they was on school break.
They were down, all right, but school break is over. Here we are in October. Are they enrolled in school in Florida?
Yes.
And then they'll just have to come back and go to school in
Down here when we get everything situated.
Forest Park. That must be tricky for the 16-year-old.
Yes, it is.
That's bouncing around some. Okay. Well, that's what we'll do. I will figure out what the Clayton situation is, and if we can get you there. If for some reason that's too complicated, then I'll enter an order that lowers the bond. And then if you're able to post it, that'll for sure get you to Clayton.
Yes, I'll be able to post it if you can lower it. Clayco and the hold in Clayco is nothing but a misdemeanor for a criminal trespass that happened 4 years ago when I was leaving Morehouse College. And I just caught a criminal trespass. I had a court date for that day, June 10th, but I was in here.
So you were a Morehouse student?
I was just going to their homecoming.
Oh, you weren't a student?
No,
there.
I wasn't a student there.
Got it. Did you ever go to Morehouse?
No, sir.
Okay, because I know you're at Georgia State now.
Yes.
Okay, all right, got it. Anything else, Ms. Rios?
No, Your Honor.
Okay, thank you.
Thank you, sir.
You bet.
I'll come let you know what he does after.
Okay, so you finna go talk to me?
No.
So what this or two?
Oh, okay.
Yes, I understand.
So the warrant said he and his wife were living in the house.
Yeah, I think they were squatting.
Yeah.
Yeah. So
It's not all adding up.
no, not at all.
Relatives.
Yeah.
Right, and their kids are in Florida and. Okay,
Yes.
Is it Morehouse in Clayton County?
Morehouse is HBCU campus right there.
I didn't get one.
Right.
Yeah.
It may have been a similar living situation in Clayton County, if they're in these,
Situations.
right.
Yeah. Interesting.
So have you and Ms. Wood talked about whether there's stuff on these calendars that we could do?
I sent her literally yesterday, late afternoon, all of my final plea offers for her clients.
Thank you for doing that, because those calendars aren't for a bit. I see we have a few things on for Friday, because Friday's open.
So she's called me and she said that, she's going to try to reach out to her clients and see what she can get scheduled.
Okay.
There might be potential at least 2 or 3 cases, but we'll see where they shake out. And they're people with multiple cases.
Okay.
So that should be good. But I'm sure she'll let Ms. Nelson know when she gets a confirmation.
Got it.
Yeah, I think Friday will be busier than today.
I won't be here Friday.
It's because you don't have any cases left.
You going to England?
No, I'm gonna be at home.
Okay.
I wish I could go to England. I haven't been to Europe yet.
It's there for you. All right. Let's see what we have here. How you doing, Mr. Lewis?
I'm doing awesome.
Good. Awesome is good. I'm just getting up all your information. Okay, let's get on the record with our last thing for, it's not this morning anymore, for today, for this calendar. And that is 16 SC 143530, old case. State versus Lewis. Jeremy Lewis is here in court with Ms. Rios. We've got Ms. Davis for the state. And in July of 2023, I signed a probation warrant in your case, Mr. Lewis. And the allegation was that in April of 2023, so a long time ago, you committed a theft by taking, had a gun, all this stuff in Douglas County. And I think we've had a conversation about this before, so I'm not sure, I'm not remembering if it was, hey, he wants to have an evidentiary hearing, but I don't see any officers, or if you were looking for a program or what was going on. I'm gonna let Ms. Rios get us up to speed. But it's a non-technical violation. It's basically new charges. They're just not new. They're from 2023. We're now deep into 2025. You've got 1 year and 10 months left on your probation. And do one more thing here. You've been in for 2 months on this. So that's what I've got.
Yes.
Tell me if Mr. Lewis is working this out by stipulating, or maybe Douglas County's already resolved it, or what happened?
We are stipulating, Your Honor. The reason why we got pretty far in the probation revocation last time, the reason we reset was to find out more information about the case in, what is it?
Douglas County?
Douglas County, and to see how long he's been in jail. I did get proof of incarceration.
From the Douglas County time?
Yes.
Okay.
The problem is he's saying that there's more than what I was sent. They're saying it's only been 5 days. But he said he spent some months there, but I've asked him and they said this is all they have. So I did my part, and I believe she looked into the actual case.
Yes, I think a part of the confusion was whether or not a gun was involved in that theft. The theft was the theft of a gun. So I was able to obtain the accusation from Douglas County. It's my understanding that that case is in a hold pattern. And they do have a warrant for that case. It does say it's dead docketed. I did get clarity from the clerk to make sure what that meant. Is it like a dismissed status? But they said that's just how they hold the case.
It's like our judicial hold.
Yeah, and
So-
it just says dead docket, so it threw me off.
Got it. So hypothetically, if whatever we did today resolve things for Mr. Lewis, he would go to Douglas County in custody because there's a warrant and would need to post bond or do whatever has to happen in Douglas County.
Yes, Judge.
Got
My
it.
understanding, they did provide a copy of I believe, the warrant to me as well.
Okay. And the reason why there's a possession of a firearm by a convicted felon is because it was a theft of a gun. To take it, you possessed it, and that's the basis for the 2 counts.
Yes.
Okay.
I do want to add, though, my client's maintaining that he did not have a gun on him. It doesn't say anything from what I saw when I quickly read the police report that they arrested him with the gun. It was his ex saying that he took her gun, but he's saying that he did not take her gun.
Got it. So it may end up being a he said, she said. What it is most of all is a Douglas County situation and not a Fulton County situation. So we ought to get Mr. Lewis moving in that direction. Ms. Davis, what is the state's recommendation?
I believe probation wanted to revoke the balance and then close the case out. We'd be recommending a year and close it out.
All right, Ms. Rios?
That the time he served and then revoke the time he served and then continue him on the probation.
So we would have to count that based on your homework of only 5 days in Douglas plus 59 here, basically 2 months.
Yes, Your Honor.
Okay. Mr. Lewis, the address that we had at the time I signed the probation warrant, which again was in 2023, was an apartment on North Avenue. Was that a good address for you at the time?
Yes, sir. At the time, it was a good address. It was to my grandmother. She's a retired military veteran, and like when the family's kind of like going through problems, because we all are like have like military backgrounds, we just go stay under her, and we get back on our feet and go in our direction. But she's moved to an elderly home by Clark, Atlanta, and I have my own house now. And
where's your house?
My house is a brand new home on Campbellton Road on 1336.
So it's in Fulton County. It's just off Campbellton Road.
Yes, sir.
Okay. And how did you get the brand new house?
I worked very hard with some realtors when I first got back. And
when you say got back from?
I went to Texas to work out of town, and I got in a gigantic car wreck, which caused me a super big accident on my head up here.
Okay, I see that.
And I almost died from that accident, and I missed going to court in Douglasville because I was like,
for this situation with the supposed stolen gun?
Yes.
Okay.
It's the only reason why like they had like a real warrant out for me, because I would have made the court date, but I was in ICU.
Texas?
Yes.
Okay.
What
kind of work were you doing in Texas?
Construction, plumbing, just house building homes, learning how to read blueprints. It was kind of like an all of the above apprentice job.
Sure.
And during that duration, once I was stranded, I didn't have no insurance on my Palisade, so I lost the car. It was deemed totaled, and I had to like try to work, and I ended up losing my job because I didn't have a way to get there. So it made me homeless, and I had to leave Oklahoma and go to Texas to be homeless. I went to a place called The Bridge and Our Calling, which helped reboot me and got me back on the path to get back to Atlanta. I got like tickets from the program. And once I got to Atlanta, I found out I had warrants in Douglasville, but I wrote them and let them know, and I sent them pictures of the status of like, my x-rays and things of the sort. So I don't know if they got it or not. I'm pretty sure they probably didn't. But I got to working with a realtor who heard about my story because I was writing a story and I was posting it on my page. And he was like, hey, if you need a job here, you can come work with me. Well, he would come work with us on the site, and we had like a whole second floor fall in, and I had pushed them out the way of the floor, and it kind of like fell on me, but it didn't bother me at all. So he was like, man, you really just like saved my life. He was like, I don't know where you came from. He was like, it was just perfect timing because he more than likely would have died.
Right.
So for like a gift out of nowhere, you know, it wasn't nothing I was asking him for. He was like, hey, do you got somewhere to stay while you working? I was like, you know, I'm staying with my grandmother right now. He was like, man, I got something for you. I got a gift for you. He was like, I want you to watch my property for me, and I'll allow you to stay at my property while you work for me.
So that's the house you're talking about.
That's the house I'm talking
All
about.
right, so you don't own it, but you can stay there.
Yes, but it's like now he just told me to keep it up. It's, you know, I don't pay nothing on it. I just take care of it. It's not mine, but it just feels like mine.
Sure.
You know?
Well, and it's a place you can go.
Yes.
Okay, got it. Were you in the military?
I was in the Marines, not for long. My mother and sister passed away on the same day, and I went AWOL after the graduation of Paris Island, and I never came back. I kind of was like just out of it.
Okay, that could do that.
I never tried to like take any accolades for the Marines. I did learn a lot.
Yep.
I did go to a very high extent to graduate. It was worth it. It helped me stay alive today. Like the training of the Marines, if I didn't have the training, I would have been dead a long time ago.
Okay, well, we should be grateful for that.
Yes.
All right, what I'm going to do, Mr. Lewis, in light of the stipulation that you were arrested for this, and it's now been accused, and he's pending out there in Douglas, and some of the other things that have been going on, I'm going to revoke 6 months of your probation. You'll get credit for all the time that you've, you know what, I don't want to get sideways with credit and all that. So what I'm going to do is revoke 4 months of probation, knowing that you've already done 2 in custody. So revoke 4 months of probation, reinstate the balance, and you will get to Douglas ASAP, so you can sort out whatever that situation is. But that leaves a year and some change of probation that you're still going to need to make sure you're reporting on. If you are living in that house on Campbellton Road, then you'll be reporting here in Fulton County. And you'll obviously need to clear up the charges in Douglas, but I know you'll do that. You'll need to show up, okay?
Yes, sir.
Ms. Davis, anything else?
No, Your Honor.
Ms. Rios, anything else? Officer Okuzu,
can I add one thing in, sir?
You can, just give me 1 second.
Yes. He can report to the Atlanta DCS office once he is released from Douglas within 48 hours. That office is located at 276 Memorial Drive, Southwest Atlanta, Georgia, 30303.
Does he have an officer right now?
He does. I can also give that information as well. It's Officer Conley. So he can contact her as well once he is released. I can provide the number over chat. I kind of don't want to give her number publicly.
That's fine. If you'll send it to me over chat, I'll write it on this little card here and get it to Mr. Lewis.
Sounds good, Your Honor. Thank you.
You bet. And when you say release from Douglas, I don't know that he'll be released from Douglas. He's got 4 months for revocation. It might be he goes to Douglas and in a day they clear that up, then he'd come back here. So he might be released from Rice Street rather than Douglas. But my guess is you're right. That's where he'll be done.
Okay, sounds good.
All right. All right. So Officer Conley, and I will look for the number.
Okay.
So then call me and I'll check when everything's in.
Okay.
Where? You're here. It's another fire?
Yeah.
All right. Deputy Gordon, can you give this to Mr. Lewis, please? So that's the phone number for your probation officer. And if there is nothing else, good luck with everything.
Yes, sir. I just wanted to ask, does the 2 months count 2 for 1 on the probation, or is it just I have to do 2 more months?
So the 2 months doesn't I was going to revoke 6 months.
Yes, sir.
Knowing that you'd already done 2. But what I've learned is rather than worry about credit for time served, I should just do the math in my head. 6 minus 2 is 4. So 4 months is 4 months from today. No credit for what you've already done. So I think another way to ask your question is, will you get 2 for 1 for your 4 months? And that's a sheriff question, not a me question.
Okay.
All right.
Thank you, sir.
Take care. I think that's it. Ms. Rios, do you have anything else? Thanks. Thanks, Ms. Davis. See you Friday.
In your Brenda Virgin, Spanish interpreter, we have someone observing, so I wanted to see your report.
Great. Yeah, unfortunately, it was a very brief observance.
We watch it on Zoom.
Oh, you've been watching it all on Zoom, and we'll be YouTube.
Sorry.
All right, we'll take that too. We'll be back Friday doing more of this. We're picking a jury tomorrow. You could observe that, but that's different kind of work.
She's a Mandarin interpreter.
Okay, great.
Yeah, I'll be traveling, but Friday I should be able to.
Okay, yeah, come back Friday. 9 a.m. we start doing stuff.
Tomorrow, for the jury, was that a year or just something in the courtroom?
It'll be right here, jury selection. It will not be on YouTube. We don't broadcast that because the jurors share personal information and all that. So it is physically open to the public. You could sit in the courtroom, but I don't push that out over the YouTube.
So we were there, do you have a private schedule?
Monday, the trial starts.
Okay.
Monday morning, and that'll be on YouTube, but it'll also be in this courtroom. So if you want to be in person, come join us, or you can watch it.
Okay, Monday I watch it. I'm in Florida.
Oh.
Well, it's like of Georgia, we have a much better court system that they feel like, it does scale up with the process. Maybe half a year. 1 year and a half process.
Oh, well, I'm glad we're more efficient, and we could always use more Mandarin interpreters. So I hope you head on up here.
Thank you.
All right, thanks.
Your Honor, may I be excused?
Yes, Ms. Smith-Mann, Ms. Rivers, Officer Okuzu, thank you for helping out today.
Okay, thank you so much.
Bye-bye.